Okay, please call the matter, Madam Deputy Registrar.
Thank you, Judge. Good morning. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize, hearing of the appeal and cross-appeal in CCJ Appeal BZCV number 3 of 2024 between Controller of Supplies, Minister of Economic Development, Petroleum, Investment and Trade, and the Attorney General of Belize against Gas Tomza Limited, Western Gas Company Limited, Southern Choice Butane doing business as Zeta Gas, and Belize Gas Energy Limited. The members of this morning's panel are Mr. Justice Anderson, presiding judge, Madam Justice Rajnath Lee, Mr. Justice Barrow, Mr. Justice Jamadar, and Madam Justice Ononiru. May we have the appearances, please?
May it please the court. Eamon Courtney, appearing for the Attorney General. Appearing with me are Ms. Samantha Matute, Assistant Solicitor General, and Ms. Ileana Swift. Appearing for the first two appellants are my learned friends, Mr. Edward Fitzgerald, Senior Counsel, Mr. Andrew Marshalek, Senior Counsel, King's Counsel, much higher than Senior Counsel, and Ms. Angeline Welch, King's Counsel. Appearing for the respondents are my learned friends, Mr. Douglas Mendes, Senior Counsel, Smith, Senior Counsel, Mr. Luke Hamill-Smith, and Mr. Hector Guerra. Your Honors, with your permission, we had indicated to the court that I would go first for the Attorney General, and then I would be followed by Ms. Welch and Mr. Fitzgerald, and then Mr. Marshalek. And we had sketched out the areas that we intend to address. That is convenient with the court. I would then present the opening on behalf of the opening of the appeal and the areas that I intend to address.
Thank you, Counsel, and thank you for those appearances. Just two very small points. One is that we have gotten the schedule, the running order that you proposed, and we are very grateful for it. We noticed that it does not necessarily correspond with the schedule of hearing, which had been distributed before, in the sense that the breaks are a little different given the running order that you are proposing. We're not intending to interfere at all with the order in which you propose to submit. We're simply saying that we notice that the breaks might be a little differently, might come a little differently because of the running order, and that is fine. That's not difficult. The second observation to make is that in looking at the running order, we did not see, at least I did not see, an indication of addressing issues relating to Section 6.
I will be doing that. I was going to say that I would add that to my opening this
your portfolio of opening remarks. Okay. Very well then. So I think you're on the clock from this moment on, and please proceed.
Greatly obliged. I would start with apologizing. The Honorable the Attorney General intended to be here, but there was an event last week with the people of Belize, and a government is being restored. Prime Minister said he should stay at home. So I apologize for his absence. I do see representatives for the respondents present. Your Honors, I would like to start by addressing the court on what we regard as critical issues of context, because it is our respectful submission that in addressing this matter and resolving it, the court must have very much in the forefront of its mind question of what are the constitutional rights at stake, the consequences if this court were to find that there are breaches of those rights, because then this court will have to fashion an appropriate remedy. There are certain realities which, in all respectful submission, ought to be taken into account when the court is deciding this matter. We say very firmly that the Court of Appeal was wrong on Section 17, that is, and Section 3, property issue, and Section 15, the right to work. We say that the result on equality, freedom of association are right. We ask the court to allow our appeal and to dismiss the cross appeal. Your Honors, this court, as we telegraphed in our first submission, will define for the Government of Belize the contours of its power to reform, to regulate the sector of the economy. It is going to be a landmark and defining decision in that regard, with legal and practical ramifications. Does the National Liquified Petroleum Gas Project Act, a reforming act, violate respondents' constitutional right? Are the regulatory measures introduced by that act constitutional? And as I said, what is the proper approach for the court to adopt when looking at an act that seeks to regulate a sector of the economy? Players in that sector challenge the constitutionality of that of legislation.
Mr. Courtney, could I add to what the president added about what I saw missing in the matrix that you gave us, and that was the argument about the original act as against the amended act. Are you going to deal with that as well?
Well, as I understand, perhaps Mr. Mendes can address that issue.
Thank you very much, Your Honor. We will not be arguing that the amended act is invalid because it amends a void act. We will be maintaining that the original act is unconstitutional. We will not be arguing that the amended act is invalid simply because it amends the void act.
Yes, thank you very much.
Much obliged, my learned friend. Your Honors, we say that the purpose for this legislation is clear. It is set out in the long title to the original act and the amended act. And the long title for the original act is to be found at page 798 of the record. And I will just very quickly read it. It says, an act to comply with and give effect to certain undertakings and obligations of the Government of Belize under and in connection with a public-private partnership agreement for the establishment, operation, and transfer of a liquefied petroleum gas terminal and related facilities in Belize for the proper rationalization of costs, supply and pricing, and enhance efficiency of the liquefied petroleum gas sector to optimize quality control and in the overall interest of the public, to provide for certain exemptions from taxes and duties, and to provide for matters connected therewith or incidental thereto. We say that it is clear that it was the intention of Parliament to reform the LPG sector by introducing a new regulatory regime. And we ask this court to give full faith and confidence to the declared intention by the Parliament. Your Honors, and we will hear this repeatedly, it was the intent of the government to liberate this sector from the Zaragoza brothers oligopoly for reasons proven in evidence. And it is critical for the court to appreciate that there is a reality on the ground that existed that caused insecurity in the supply of LPG to Belize, that caused transfer pricing in that sector, that caused questions about the quality of LPG sold to consumers, and indeed, there are serious problems about smuggling. These are issues which the legislation sought to address. Mr. Joseph Waite, Financial Secretary of Belize, in his affidavit at page 2855 to 2857, sets out very clearly the bases which the government was moved to act. Your Honors, in the interest of time, I won't turn these up, but I'm happy to say that the evidence is also contained in the affidavit of Mr. Nicholson. The first additional point I wish to make at this stage, because there is an insinuation, to put it in the most anodyne way, government was acting from a position of perhaps bad faith or ill will in seeking to put the respondents out of business. That is not so. The Amendment Act, Your Honors, is a clear piece of evidence that the government was not intending to put them out of business. The government was intending to move the supply of LPG from road to sea through a facility that advanced the purposes. When the litigation was started and there was a complaint or a challenge to the exclusivity, the government leveled the playing field on the importation side and provided the right for someone to apply for a license to import LPG through an approved facility. So I just wish to make the point that in this regard, the 1.5 million gallons criteria was designed to level the playing field. What do I mean? Anyone, any of the respondents,
Courtney, what was the size of the government facility again?
1.5 million gallons.
So this is sort of a same size facility
Yes,
as was established by the government.
yes, by the National Gas Company,
Yes.
right?
Sorry.
So I was just simply saying that what the government was saying is, okay, we will liberate the importation, but anyone who wishes to come in on the importation must have a facility of the same size or greater if you wish.
Could it have been on land? Did it matter?
Yes, it did matter, Your Honor.
This option to level the playing field by establishing a 1.5 gallon facility had to be a port-based, a sea-based facility, or was it open-ended
Well,
under the amendment?
what I would say is, having regard to the issues that the reform sought to address, including the insecurity caused by bringing the LPG by road through Guatemala.
Yeah,
So it has to be a port and come by sea.
right. So, and the amendment specifies that. So it's not just 1.5, it's 1.5 with a port by sea.
But it has to be an approved facility. It doesn't say that the approved facility must be a port, but it follows. If you allow it to come by truck, have defeated the purpose. So the inference is that it must come by sea.
What do you say of the onerous nature that has been argued that this is an onerous condition or precondition?
Your Honor, we say, first of all, the analysis that is relied on to reach that conclusion, the study by the accountant, Mr. Sanchez, is deeply flawed. First of all, he was presented with the accounts of the company, which were not audited. He was given instructions what to do. Thirdly, his analysis was based on the definitive agreement and the contours in the definitive agreement that have been translated into the legislation. None of these companies are parties to the definitive agreement, and there is no reason to believe that if they came with a proposal to the government wanting not 15, but 20 years or 25 years of wanting different incentives, there was a cocktail of fiscal incentives that were provided to the National Gas Company. There is no reason to believe that they would get.
So no, let me understand. So are you saying the same tax breaks and all of that that NGC was given? Because NGC got both had to build a facility. The funding for building that facility came from
Private sector, by loans from the IDB, by bonds, by equity.
and all that was guaranteed by
Wait, I wouldn't say it was guaranteed, Your Honor. They have taken the risk.
right. So
They-
the NGC is a state corp company, and it took the risk of establishing its own facility.
Yes, government having a 25% stake in it, government providing it with a slew of fiscal incentives in order to construct, then those particular incentives fall away. Post-operation, after commercial operation, they are exempted from
And
income and
is
business
that
tax.
similarly in leveling the playing field? Is that similarly offered to independent contractors who want to compel to establish a same size port facility?
Well, what I was trying to say, Your Honor, is two things. First of all, in our submissions, we have put a footnote of about 6 or 7 pieces of legislation for different industries to show that when a major investment like that is going to be made, the fiscal incentives are ordered. The amendment that are provided, the amendment legislation doesn't set out to say that if you come and say you want to build a 1.5, these are the pieces of, these are the fiscal incentives that you will get. It doesn't say that. As is said in the evidence from Mr. Nicholson and Mr. Trejo, if a party says, I want to do a $50 million or a $60 million investment, they go to government and say, here are the investments. I need 20 years. I need exemption from import duties, environmental tax, GST for 5 or 10 years, as the case may be. It has to be negotiated based on the practicalities of the proposal that is put before the government. The point that Mr. Nicholson makes, the point that Mr. Trejo makes, the point that the financial secretary makes, is that that is open to any of the respondents to come to government with a proposal. On the facts of this case, they did not make any proposal. They made no application. They simply said, if we were to be given the very same terms and conditions as were given to NGC, according to our accountant, it would not be economically feasible.
Before we leave the storage facility and the capacity of 1.5 million gallons, I think you had given us some rationale as to why the government thought that building this terminal was very important to regulating the LPG industry in Belize. But for just a minute or so, could you explain why the 1.5 as opposed to, 2 million, for example? I gather that the capacity of the gas companies prior to this was about 300,000 gallons, which would supply Belize, generally speaking, for about 7 days, whereas the 1.5
days.
capacity could go for a month or so. Was that a crucial factor in deciding on the size terminal that was appropriate?
Was indeed a crucial factor, Your Honor, both from a security, energy security point of view, stability of prices point of view, and most importantly, from a financial point of view. The business plan that was presented, in order to finance a facility, you needed a minimum throughput. You needed a minimum amount to go through that facility. If you're going with 300,000, then it just can't finance a 1.5 gallon facility, 1.5 million facility. Your Honor, I say in passing. In fact, there is evidence that by the time the matter came to trial, I believe we were already importing 14 million gallons per year. The difficulty with a $200,000 and a $300,000 and a $50,000 gallon facility is that trucks come in every day across the border. Every day, permits are applied for, trucks are coming in over and over and over, creating a risk. Before I move from this, Your Honor, so I just want to confirm to you that, and Ms. Wells will go in detail on this, 1.5 million gallons is essential for this project to be a success.
That is the NGC policy per project.
Right.
But I suppose part of what I would follow up and ask you is this. If the government determined after due research, etc., that a 1.5 facility under the original act, which I'm not trying to get into the legality of it, would have been sufficient to meet the needs of Belize as it had intended to establish in originally. All right. Then if you have that and that was deemed sufficient, what was the necessity for having several of that? So that 1.5 was deemed sufficient to meet your security, supply, your cost analysis. What if a smaller operator said, well, okay, you're taking care of Belize. This is good enough to meet all your security, etc. needs, and it's whatever, that's your business plan. I want to do a 300. That's adding on to your 1.5. I want to be a smaller operator. Why is that? I'm trying to understand why is that problematic if you've already covered with your government project the security, supply, consistency needs.
Your Honor, 1.5 is not sufficient. 1.5 is the minimum to allow the project to work. The country is actually using in excess of 14 million gallons.
So therefore, having additional facilities is desirable.
Right, but the reality, it is. And that's why government amended the law. But however...
No, I understand that. So what I am trying to understand is, for the government project, 1.5 was economically feasible for whatever reason. We don't need to get into details. Let's accept that. Why impose that on everybody else who is going to help meet what you say is a need in excess of 1.5?
Right.
That's what I would like
I
to
understand,
hear.
Your Honor.
Yeah.
What I'm trying to say to you is the following.
Mhm.
14 million, which is roughly, let's say, 1 million per month,
Mhm.
if we break it down. The need to go through the facility is 1.1. If we say someone can bring in 300, then for that month, it will not, 1.1 will not go through the facility.
So therefore,
What I'm trying to say is
no,
that...
hold on. So that you needed
Right.
to create a monopoly to get, just hypothetically, 1.1 to make your project a success.
Yes.
And anybody who threatened that minimum threshold had to be excluded,
The word you use is threaten, I would say undermine.
undermined.
Yes.
So that the government set up the NGC project. It needs 1.1. It eliminates any competition that can undermine the minimum, let's assume is 1.1. All right?
Yes.
But you have just said that the government can get 14 million. So where is the threat? In other words, you're crossing the 1.1 in, as we say, spades.
No, Your Honor. No.
Oh, I misunderstand.
No.
Hmm.
There's a difference between what is needed every day
Mhm.
and what is needed every month and what is needed throughout the whole year.
Yes.
And all I'm saying to you is if you allow someone else to come in with a facility of 100,000, 300,000,
Yes.
whatever, every gallon
Yes.
for this month
Yes.
that is being used from there
Yes.
is not being used through
NGC.
NGC.
Yes.
And that undermines the financial viability.
Provided NGC can only make 1.1.
Mr.
Suppose NGC can make more. Suppose NGC makes 1 point. Let's use 1 million as an easy figure for me.
Yes.
Suppose NGC needs 1 to be viable, and is getting 1.5.
It is getting,
Yes. It is getting 1.5 because you said the minimum capacity is this, but it can exceed the capacity,
Yes.
right? Then that extra 500,000, it doesn't need to monopolize.
Your Honor.
Yes, Mr. Courtney, we have a long ways to go. And I just wondered one way of looking at this is whether you are retreating from very clear statements you made in your submissions. One of those statements was to the effect that you thought that the government had the power to create a national infrastructure that businesses were required to use in order to pay for that infrastructure. Is that not one way of looking at that issue, or are you retreating from that?
I'm absolutely not retreating from that.
Before you go further, let me add to my brother's question. Because I see that in the amended act, there is provision to allow others to use the NGC terminal so that somebody, it seems to me, and just this is speaking very broadly as a matter of impression, according to that, somebody can import other than NGC, can import using the NGC operated terminal and, as it were, do their own retail, their own wholesale from their supply, which lands in NGC's terminal. Is that the fact as contemplated by the amendment?
The legislation contemplates that.
Okay,
It
thanks.
contemplates you build your own facility, 1.5 minimum. 2, you apply for a permit to import through NGC's facility. That is section 6B. You apply to participate in the tendering and say to NGC, we can supply LPG for you at a lower, on the tender process, at a lower price. So they're entitled, they shout and scream throughout their evidence that they can get LPG at a cheaper price from their sister companies in Honduras, Guatemala, and Salvador. Well, get it and supply it to the National Gas Company. They can do that. They have chosen not to do that, and they have chosen not to do that because in our respectful submission, they want the status quo ante to prevail. They want it to revert to the situation where they can get petroleum, liquid petroleum gas from a sister company at a price that they choose, which is then foisted on the Belizean people. We say and we repeat, that is transfer pricing as is going on, predatory pricing is going on, security risk going on, moving these things through Guatemala, and the government has taken, to the president's point, a policy decision that it is going to establish a public-private company that is going to have the right to import LPG into Belize using sea route to a landed facility where all the testing can be done, all the measuring, storing, etc. can be done, centralize it. Anyone is entitled to use it, either from buying from it or to bring in through that facility. We do not resile from that 1 centimeter. The point I wish to make in opening is to remind this court that this is a public-private partnership. Government has a 25% stake in it. In 10 years' time, this facility will be wholly owned by the state of Belize.
I thought it was 15.
But 5 years have
I
passed.
see. Oh, yeah. That's long. Okay.
So in 10 years, this is going to be a state facility, and this is just the mechanism that is being used to finance it. Whereas the final point I want to make on the introduction and the opening is the question of importation. The respondents continue to carry on their wholesale and retail business as I stand here. The intervention by the state was at importation. Bring the LPG by sea to a facility. They can import if they wish, apply for the license and bring it through that facility.
So when you say they continue to conduct the wholesale retail business, you mean using
Liquid petroleum gas from the national gas
LPG
company.
from NGC?
Yes.
Yeah. Mhm. Because they have no choice right now,
Well,
unless they build a 1.5,
or unless they bring in their things through the facility.
but they have to tender for that.
No.
No.
That's a separate thing. The tendering is if they are going to supply to NGC for NGC to on sale.
I see, right.
Or they can apply for a license and say, I want to import it. I will not build a facility, national gas, I'm bringing in whatever the amount is this month, next month, etc. And they strike a deal with national gas using their facility to bring it in.
And what are there conditions attached to that?
They have chosen not to do it. There are no
No, are
conditions.
they under the-
It's a purely commercial arrangement. They have chosen not to do it. And yes, so the final point I was making is that it is at importation that the government passes legislation to create the exclusive right for the national gas company, and they have now liberated it. There has never been any provision in law that seeks to restrict or interfere with their right to conduct their retail and their wholesale business.
So council, the gas companies continue to have wholesale customers, you said?
That is,
I- Just seeking clarity. They
Yes,
continue to
they-
have wholesale customers.
yes, they complain that because the legislation sets a wholesale price, some of their customers have left them and go directly to the national gas company. The national gas company makes the point that they are not in retail business. So you can't drive up with a 50-gallon truck or a 100-gallon truck and say, I want. They only sell a minimum of, I think it's
3,400.
3,004.
Yeah. Right.
3,400.
Right. So, and that's not a big part of, that's not where their business is. Their business is bringing it in and selling it to everybody, to all of them. So they do conduct, and my learned friends will have their say on it, but they do provide.
But that aspect, Mr. Courtney, is not regulated. There's nothing which says that the gas company cannot sell in lesser denominations than 2,400 gallons.
It is not.
Okay.
But it's not their business model.
Okay.
Now, let me very briefly summarize. I had a presentation here on our assessment of the evidence put forward by the respondents. I will just summarize it in bullet points.
I know you will, but Council, I think when you stood up at first, you had promised us to say something about your view of the role of the court in dealing with these socioeconomic matters. I assume that that is still on the list of promises. Yes.
Getting there very quickly, that's why.
Wonderful.
Insofar as the evidence of the respondents is concerned, we make the following 4 points. They believe that the reforms introduced were unnecessary. Secondly, that they have lost profits and they have lost business. We say their evidence, there is no proof no proof of loss of goodwill. Finally, they all continue to operate their businesses in the retail and wholesale space. Your Honors, very quickly, the government of Belize took a decision, policy decision, cabinet, relying on section 44(2) of the Constitution, which constitutes the cabinet as the primary policy-making, principal executive instrument of policy in the country. And the legislation enshrined into law the policy decision was passed by the National Assembly pursuant to section 68. We say this decision, the policy decision, economic and social policy decision, are grounded at the level of the Constitution. This is not someone, some administrator or some state entity making a policy decision, setting a policy decision for a state enterprise. This is the government of Belize making a social and economic policy decision. There is a consequence of that. First consequence we say, Your Honors, and I will just read paragraph 51 from the Albert case and 117 of the New World case very quickly. The executive has a wide discretion in selecting the means to achieve its constitutionally permissible objectives. Courts may not interfere with the means selected simply because they do not like them, or because there are other more appropriate means that could have been selected. But where the decision has been challenged on grounds of rationality, courts are obliged to examine the means selected to determine whether they are rationally related to the objective to be achieved. And we emphasize this. What must be stressed is that the purpose of the inquiry is to determine not whether there are other means that could have been used, but whether the means selected are rationally related to the objective to be achieved. We emphasize that gas companies
Mr. Sports, so that in that formulation, under the constitutional regime and the cases you have cited, even when it is a socio-economic policy taken at the highest level, the cabinet, section 44(2), courts still have a role to play. You accept that, don't you?
Absolutely.
And I think you have outlined the aspect of rational connection. I'm just trying to clarify something early on. So is that the only filtering lens, rationality? Or is it, do you accept that it also, because you accept that much from what you've cited, I guess, do you accept that it may also include a proportionality filter? That is to say, and I suppose you're going to get there eventually, so this is just a summary. I understand that. Mr. Gerald may come to that more deeply. But just because of what you said and cited, which talks about rationality, what is your side's position? In summary, obviously.
I was about to say, I will just headline it because I leave it to Mr.
I accept
Fitzgerald
that.
to develop it
Accept
fully. But say, in our respectful submission, the first issue is rationality. There may be circumstances where, quote unquote, because of the effect of the measure, a proportionality analysis may arise.
And therefore, I don't want to take it too far. I respect that that is someone else. To get there would be a question of circumstance. In other words, you can only know effect if we look at the evidence. Obviously, that's not a theoretical construct.
Indeed.
And so that your summary position would be rationality must always be there. The purpose must be linked to the objective, the means, the objective rationality. And depending on the effects, then position is proportionality may arise. Is that fair to you?
That is correct.
Okay,
Do you say very quickly, Mr. Courtney, do you say that in this case we come to proportionality?
My respectful submission is no. On the property issue, for the reason that what they assert but have not proven is impact supposed loss of goodwill, which is a intangible. They're continuing, contrast that with Manitoba fisheries. Manitoba fisheries, where the intent of Parliament was to prohibit Manitoba fisheries and like place companies from conducting their business, and provided in the legislation for compensation for your equipment that became redundant. That was never the intention of government here, not that they should go out of business. It is simply to say the way that LPG comes into the country will come from a different route. You continue to carry on your business. They say, my goodwill has been taken. I say that that is a marginal deprivation. If the court accepts it, we say they have not proven it, and in fact, it has not.
So that just to maybe just summarize that in terms of because the impact is obviously on a range to trigger, right? So I think we accept that.
Yes.
And so you say at best, if you say not at all, not proven, I should say. You say not proven, but if proven, marginally so. So it doesn't reach the threshold of a significant impact to justify a further constitutional inquiry into the vagaries of the amendment.
Right.
Yeah.
We also, Your Honor, and this, again, my learned friends will develop it, and I don't want to be taken to not be pressing it. We also firmly submit the Societe, United Docs, etc., that there is a fundamental principle that where legislation is regulatory, courts accept that the impact on some may be more than others, but where it is of general application, courts will not find that government needs to compensate.
So are you putting it as an absolute position, or is that a may position? In other words, is the position that you want to put absolute? If a court assesses this to be regulatory, it's hands off. Or is your position that dependent on even if it is regulatory, dependent on the effect on this sliding scale we've just spoken about, a court may, what is your position? The court may.
Your Honor, Lord Carswell says if it goes
What is
to
your position, Mr. Courtney? I know what the people have written about. This is the Caribbean. What is your position?
Your Honor, my position, quite openly, is the court gives to the state a significant space, margin of appreciation, deference, whatever phrase you want to use, where economic and social policy is being considered, where legislation is looked at that implements that policy, and the reform is regulatory. The court firstly concludes that because it is regulatory and the impact on persons is, well, the court measures the level of impact. The court levels a measure of
And
impact.
if
it
the
goes-
impact is
yes.
in the Manitoba case, I'm just trying to nuance
I
the
understand.
principle, because you first stated it in a more absolute sense, which knowing you, I am surprised that you would say that. Maybe Lord Cardwell may say it, but I'm surprised that you would say that. So that's why I'm interested, Mr. Courtney, you're a very senior Caribbean practitioner, in what your position is. And so therefore, is it then that we also, even if it's regulatory, and even if in that context you pay greater deference, let's say, you still may look at impact, and if the impact is significant, then that may be a consideration. That's all I'm asking. Would you
Yes, yes,
agree
Your
with that formulation? Yeah, thank you.
I personally would.
No, that's what I appreciate, Mr. Courtney. Thank you.
Your Honor, I'm running out of time, and so I have to take some bullet points at this stage. Insofar as reform of the industry is concerned, of the sector is concerned, and the result and the right of government to regulate, we rely on Societe United Docs, and we rely on South Africa Diamond, particular attention to the dicta in South Africa Diamond Producers, because there you have a very similar situation as we do in Societe United Docs. So those two cases are key on that thing. Insofar as the separation of powers and the deference point is concerned, which was deplored and deprecated very seriously and with respect wrongly by the Court of Appeal, we rely on Zuniga at paragraph 49, Arorangi at 38, 39, and 41, and Grape Bay, pages 14 to 15. Your Honors, can I just quickly say something on section 3 and 17 of the Constitution and then make a few comments on quality?
I just wanted to ask, were you through on your evidence, Mr.?
Sorry?
You had mentioned that you wanted to speak about the evidence of the respondents
Well,
in the case.
I jumped
Were
over
you
that because,
Because I know we asked you and we intervened.
yes, I jumped over that and I just gave it a 4 bullet points. I was going to go into more details about the our assessment of their evidence, but I don't have the time.
I catch it, yes.
Your Honors, section 3 and 17. Section 3 of the Constitution, 3D to be specific, provides for the protection against arbitrary deprivation of property. Section 17 of the Constitution provides for compulsory acquisition of property or an interest right over property, taking possession of. We say Caribbean Management Case acknowledges that difference and says that Section 3D deals with a deprivation which the property does not go to government, a person loses his rights, his property rights are extinguished or restricted, but it does not inure to the government. Section 17 deals with a government acquisition, taking title. We say that under Section 3D, it expressly uses the word arbitrary deprivation. Under 17, we know what the situation is. There has to be a public purpose. There has to be reasonable compensation. It has to be paid in a reasonable period of time. All of that can be tested. Access to the court. When you get into the public purpose, you have the de Freitas test. We say this case, even though the respondents have run it on Section 17, we say it is properly a Section 3. Analysis that this court should undertake is an arbitrariness test that should be applied, which is there a rational connection between the policy choice made and the objective which it seeks?
And Mr. Courtney, this is because you're saying there was no taking or acquisition of property.
That the property rights has been, quote unquote, impacted by the new regulation.
But not taken or
there is no-
acquired.
Right.
So the degree of deprivation really doesn't matter from that point of view. We might be revisiting a conversation you had earlier.
One of the cases that we rely on from Africa says that if it goes too far, then you may have to get into a proportionality analysis, even though it's not a taking, to use that expression.
So when it goes too far is when it has a very significant negative impact on the private citizen.
And in fact, if you look at the cases, Manitoba Fisheries being the best, they talk about obliteration of your business and just a complete taking. We're nowhere in that realm. Your Honors, at the end, can I just say a few words on equality? One, conclusion reached by the Court of Appeal was correct. We do not resist the argument that my learned friend has raised that Justice for Appeal Balkan was wrong to introduce the motivation test, that we don't support that. What we
Do you
do
agree with the motivation test?
No.
No, oh, sorry.
what we do say is a lot of time has been spent by my learned friends and the Court of Appeal dealing with Section 16. Section 16 has been abandoned by the respondents. 2, Section 16 does not arise in this case. It is a Section 6(1) that they rely on.
I think they say that. Mr. Courtney.
Yes. So, Section 6(1), Your Honors, all persons are equal before the law. And be no contravention of that principle. That's a moral principle that is enshrined in the Constitution. Regardless of who you are equal. I raise historically whether that applies to companies, but it doesn't matter. It's saying that all persons are equal.
You mean it does not apply to companies?
That would be my, yes, that it does not apply. That particular, the second part,
Section 6(1) does not apply.
the first part, we break down 6(1) into 2 elements. The first being that all persons are equal. The second one is equal protection of the law. And I'm saying that insofar as equal protection is concerned, a company is entitled to it. There's a question as to whether under the first part, all persons are equal before the law, that includes. My respectful submission of that is referring to humans. We say on the facts of this case.
You have a reason for saying that in 6(1)?
Well, the submission that we make, Your Honor, is that it has to do, if I can just very quickly read one sentence. And whilst I'm saying that, we say that reliance on Webster is wrong. Section 4D of Trinidad Constitution is very different from 6(1).
So that in your opinion, the equality before the law, the Section 6(1) general moral principle, equality before the law, does not apply to treatment of company?
Your Honor, could I just read the sentence and then answer you? We rely on equality before the law, book by Michael Foran. And there's this sentence: equality before the law is a grounding moral principle of the common law constitution, without which a constitutional order cannot be said to be legitimate, nor could fidelity to the law be achieved. In my respectful submission, where in the Belize context, when you look at the preamble and when you come to Section 6(1) and it says all persons are equal before the law, I respectfully submit that that is referring to human beings. It is not, my argument is not vitiated if the court finds that it applies to companies, but I'm just saying that that is my respectful view. Your Honors, the analysis of my learned friends on equality, dealing with discrimination and being treated differently, applies to Section 16. Is for discrimination. Our Constitution separates Section 6, and if you look at the language of Section 6, I respectfully submit it's a due process section. Section 16 deals with discrimination. They have abandoned, they say they rely exclusively on 6(1). Your Honors, I have gone past my time. If I can be of any further assistance on 3 and 17, the right of government to reform the sector, the deference which a court should accord a piece of legislation that implements a social and economic policy decision taken by the cabinet, or any question on the factual overview, I will be happy to answer that before handing the baton over to Ms. Welsh.
I wouldn't want to detain you, but maybe sometime after this case, I'd be happy to chat with you about
6(1).
6(1). Whatever we decide, Mr. Courtney.
Mr. Courtney, I just have one question about the factual matrix. So if we go back to the framework of the amendment, the act that amended the original act, Part of the government submission is that if another importer were to build another facility and had to be subject accordingly to the 1.5 million storage requirement, it would also have to be subject to the wholesale price that would have to be charged. And if I wanted you to just clarify the importance of that requirement as I understand it, meaning A, the capacity of that other facility needing to be 1.5 million gallons in storage, and then 2, the wholesale price having to be charged, the importance of those 2 requirements to the financial feasibility, if you wish, of the NGC terminal. I understood that to be part of the government submission. And if you could just elaborate on that, please.
Your Honor, I am very happy to say that Ms. Welch will do that in consummate detail
Okay.
so that she can earn her keep. I won't answer it, with your permission.
Okay.
Deeply obliged.
Thank you,
Thank
Mr.
you.
Wood. Ms. Welch, welcome.
Yes, Your Honour. Your Honours, Mr. Courtney has already addressed you on the critical importance of the NGC terminal project to Belize and the regulatory regime which facilitated it. And for the first and second appellants, I align myself fully with his submission, save for one point. At the outset, Mr. Courtney made a flippant remark that King's Counsel or higher than senior counsel, of course, I don't associate myself with that. Being
I'm happy to hear that.
having the most respect for senior counsel colleagues on both sides of the table in this particular dispute. I will address the economic rationale for and the impact of the legislation. And it's critical in our submission to understand this because it shows 4 propositions which I hope to make good. First, why it was appropriate for the legislature to implement a policy which had a terminal with a capacity of 1.5 billion gallons and to make NGC the sole importer initially to financially support the policy. And that goes to the final question which was put to Mr. Courtney. Second, the claimant company's goodwill was not taken by the legislation. Third, if the claimant companies have lost anything, it is a reduction in their profits caused by the fact that the wholesale price for the LPG acquired from NGC has to incorporate the user costs which are incurred towards the construction and operation of the NGC terminal. And that we say is a tax rate or due for the purposes of section 17(2)(a). Finally, my 4th proposition, it will show that the conditions attached to the importation of LPG under the Amendment Act were appropriate to level the playing field without undermining the scheme imposed by the original Act. So, my Lords, if I may start with the purpose of the 1.5 US gallons under the original Act. As we pointed out in our January reply, and as I think the court has already alighted to from their questions to Mr. Courtney this morning, the issue of the 1.5 US million gallons arises in 2 senses. First, whether it is justified in relation to the NGC terminal. Second, whether it was justified as a minimum requirement for importing via a terminal, which is one of the conditions for the Amendment Act. I'm going to come back at the end of my submissions to deal with the Amendment Act condition, but I'm going to start with the 1.5 under the original legislation. As you've heard from Mr. Courtney, the legislative policy under the original Act was to introduce a new import regime whereby LPC would be shipped directly to Belize from the US Gulf Coast in much larger volumes and then stored in Belize. The court will have seen that we have identified 5 socio-economic policy aims behind this legislation. That's at paragraph 11 of our October submissions. Mr. Courtney alighted to them earlier. I'm not going to repeat them. I would note that in the Court of Appeal judgment Justice Balkan accepted that each of these 5 propositions or purposes was undoubtedly in the public interest, and that's in the judgment at paragraph 105. But it is the final purpose which he identifies at 105 of the judgment, which is of particular importance when it comes to the 1.5 million US gallons, and that is to secure and stabilise the LPG market by ensuring sufficient inventory. Why do I say that that is important for the 1.5? Well, that can be broken down into 2 sub-reasons. The first is that by bringing LPG directly into Belize from the US Gulf Coast as a supplier, secure supply chain, as you've heard from Mr. Courtney, you eliminate the risks to supply of LPG being brought in via other countries in Central America via the oligopoly which existed beforehand. It's also important that if you're bringing in LPG by sea, you're bringing it in bulk. So you need to have a terminal which is big enough in order to receive that LPG. As the court will have seen from the papers, the NGC terminal of 1.5 million US gallons facility took the storage capacity in Belize from a precarious 7 days to 38 days. And neighbouring countries in Central America have a capacity of 90 days. So it didn't quite get to that level. Secondly, price stability. The court will have seen that LPG prices are higher in winter months, but tapered down towards the summer months when demand in North America disappears. So simply put, if you can buy in bulk during the cheaper period and you store in Belize, you'll be able to alleviate the price pressures of higher seasons for the end consumer in Belize. We respectfully submit that at paragraph 107 of the judgment, Justice Balkan fell into error when he concluded that the devastation wrought by the cross-examination of the government's witness, Mr. Nicholson, was such that there was no credible, verifiable reason left to explain the rationale for the large storage tank. The 2 sub-reasons which I've just identified were there in the evidence, as we make clear in our January reply at paragraph 16, and Mr. Nicholson was not cross-examined.
Excuse me.
Sorry.
Did Chief Justice Arana have a position on this? Did she have a finding on this?
Your Honour, she was looking at the amended act.
What I'm just trying to understand is, you say Justice Appeal Balkan fell into error on this point. What was the first instance court's position on this point?
Your Honour, first instance court was that the policy of a 1.5 million gallons terminal under the original act was within the public policy powers of the legislature. I'll come on to the impact that it had on the business of the respondents.
So her position was different from that of Justice Balkan?
Well, I think that she was being asked to assess the Amendment Act, but insofar as the original Act was concerned, insofar as the purpose for the 1.5, she said that was within the policy discretion of the legislature. She did make a different finding in terms of the economic impact on the respondents, but respectfully, I'll come to that in a moment, if I may, Your Honour.
Ms. Welch, if you don't mind, could you just refer us back to the paragraph of Justice of Appeal Balkan's judgment that you've been referring to?
Paragraph 107.
107. Thank
And
you.
that's at page 48 of the record.
Thank you very much.
There is a...
Sorry, were you saying something about, I think you're critiquing the Justice of Appeal when he suggested that the evidence of Mr. Nicholson had been destroyed.
Yes.
Cross-examination. And then you mentioned, I think, 2 factors.
Yes.
Were you going to go on to say that those factors were not cross-examined on?
Yes, that is our submission. So the price stability, the factors, Mr. Nicholson was cross-examined on a number of the 5 rationale that we've set out for the legislation, but critically the factors which go to justifying the 1.5, he was not cross-examined on. And it was the other issue, I'll just come on to, there is a third rationale for the 1.5, which the court has already alighted on, and that is clearly, when you're building a terminal and related facilities in a project of this size, that had to be paid for. And I'm going to come back to this because I want to take the court, and I hope you bear with me when we will go to the legislation. I think this goes to the final question that Mr. Courtney had. We'll look at the legislation and the way in which the charges or the cost of the terminal construction operation was to be passed on to the end consumer of Belize.
But just to draw a line under this point, you're saying that these points were made by Mr. Nicholson in his affidavit, is it?
Sorry, Your Honour.
The points on which he was not cross-examined were
Yes.
points which he had made in his
Yes,
document to the
yes, they were. They were, Your Honour, and we've set that out at paragraph 16 of our January reply. So we've set out the references there.
Thank you. I'm advised that the IT folks would like for you to speak more directly into the microphone, please.
Okay.
Thank you very much.
Understood. I made them a bit closer to me. Your Honours, there's a third reason why a terminal with a capacity of 1.5 US gallons was required, as I was saying a moment ago, and that is to pay for it. And as we'll see when we come back to look at the legislation, the short point is that you needed a certain, or assumptions of a certain volume of the LPG flowing through that terminal in order to generate sufficient funds to support the entire project. So we say that when one steps back, when you're dealing with a project of this size and nature, it's not appropriate to test that 1.5 million US gallons requirement under the original Act separately by reference to each of the 5 identified purposes. One has to look at the objectives as a whole. And the purposes are cumulative. And with any project of this nature, there is a balancing exercise, taking all of the relevant purposes together. With your leave, Your Honours, I'm going to take you to the regulation of the LPG price and specifically the breakup in which the costs of this project were to be recouped, because this has an important impact on what effect the legislation had on the claimant company's business. The first point is that the price of the LPG was regulated before and after the introduction of the original Act. And that's not, of course, surprising because of the importance of this fuel to everyday life. It is equivalent of a true utility. The base cost of LPG was the same before and after the introduction of the legislation. It's priced on the open market at the Mont Belvieu index price from where it's sourced in the US Gulf Coast. And that did not change before and after the legislation. So the price build-up before the Act, as Mr. Courtney explained, the LPG was shipped to terminals in Guatemala, Honduras and El Salvador, and then it was trucked into Belize. By the time the LPG was trucked into Belize, the cost of the LPG to the end customer in Belize was the Mont Belvieu price and the cost of those terminals and the transportation, plus any profit element. So as Mr. Courtney explained, the supply chain was operated and controlled by sister companies of the LPG companies. So those costs for the terminal, the transportation and any profits made were for that oligopoly which existed before the legislation. Once the LPG had come into Belize, the LPG companies sold the LPG to end customers, and there are 2 relevant categories of end customers, as the court will have seen. The first is wholesale and the second is retail. The retail price was regulated by the first appellant, control of supplies, under the suppliers control regulations. This was fixed maximum price per 100 cylinders. Initially, the wholesale price was not regulated. This meant that the claimant companies could sell at a lower price than the fixed retail price to wholesale customers, though of course above the price that they paid their sister companies, and that delta represented their profits to the wholesale customers. Prior to the introduction of the legislation, a regulated maximum
So
price...
NGC, under the regulations, could do both retail and wholesale?
Yes, Your Honour. In fact, they could after the legislation as well, which we'll show you in a moment. Just prior to the legislation, there was a regulated maximum price for the wholesale that was introduced as well. So the regulatory landscape before the introduction of the legislation at issue here was that both the retail and the wholesale price were regulated by the state. So in paying for the LPG, the end customer in Belize was paying for the Mont Belvieu price plus the cost of terminals outside of Belize and transportation into Belize. And that was all passed on to the claimant companies.
That regulation was by the state.
Sorry, Your Honour?
That regulation, this is a situation where you have private entities trucking gas shipped into South American countries.
Yes.
And selling it, basically.
Yes.
Yeah, whether it was import and retail, however we work on that, we'll reach there at some point. Both of those prices of LPG shipped into South American countries and trucked into Belize,
Yes.
Prices were regulated by the state.
Yes, Your Honour.
Yeah.
In the same way as
Yes. No, right. So this was not completely free enterprise where the companies, the gas companies who were trucking it in could put whatever markup they wanted. Once it's regulated, it's regulated.
Yes, Your Honour.
Yeah.
Yes. As it is in the cases, as you will know, many utility companies,
Yeah,
the
of
state
course.
will, yes. So after the legislation was introduced, the wholesale and retail prices remain regulated. The retail price was not regulated by the legislation which came into place. It remained a maximum price and was established, continued to be established under the Suppliers Control Regulation. However, once the original Act came in, it introduced a new pricing methodology for the wholesale price. And this is important because it's this new pricing methodology which essentially funds the entire project.
Sorry, repeat the last statement. It's a new price.
The new pricing methodology essentially funds the project.
I see.
I'm going to show you that, Mr. Justice Barrow. I'm not going to take the court to many documents, but I would like to take you to the original Act if you're able to go to it. I would like to start on page 802, if I may, of the record.
Oh, there we go.
If the court has that, I just would like to draw the court's attention to section 5, because this is the provision which says that the developer shall have an exclusive right to import wholesale LPG into Belize until the expiration of the definitive agreement, and then provided that the purchase of the LPG by the developer shall be subject to an open, selective or limited tendering procedure set out in the Finance and Audit Reform Act, except the developer should be the procurement entity. Now, I'm going to come back to the importance of that, but what the change there was, prior to the legislation coming into place, the claimant companies would present the cost of the LPG in their custom reports, but there would be no disclosure of the underlying costs going back through their supply chain. Once the original Act came in, you had then a tendering process so that essentially exporters, entities who were selling LPG outside of Belize would have to tender to sell it to NGC, so there was greater transparency in the supply chain. The next relevant
And
section...
Council, you refer to transfer pricing because the state is asserting that essentially these were related entities.
Yes,
Okay.
Your Honour. Yes, Your Honour. The claimant companies related entities. And then, Your Honours, if you can go to page 804 and to section 10, which is the LPG pricing methodology. Now, this provides that the LPC pricing methodology for determining the wholesale prices for LPG sold or to be sold by the developer from time to time during the term of this agreement shall be as prescribed in the schedule. So this is only making provision for wholesale during the term of the definitive agreement and not beyond that. Of course, the developer here is NGC and the agreement is a definitive agreement. And then if you can go to the schedule, which starts at page 805 of the record, that sets out the LPC pricing methodology. And the starting point is on page 805, the definition of wholesale price. And you'll see there, the wholesale price is broken down into 5 different components. The first is the landed price. And if you were to go back to page 806, you can see, sorry, the landed cost. If you go back to page 806, you can see what the landed cost is. And that is essentially the buyer price. So the entity contracted by NGC to buy the LPG, and port dues, brokerage fees, port throughput fee, that's the fee charged by the Port of Big Creek. So what this is essentially doing is identifying what the cost of the LPG is once it gets to Belize. If you then go back to the wholesale price on page 807, you see that the next component is the financing fee. And this is this reflects the way in which the legislation makes provision for financing of the project. And you'll see the financing fee is set out on page 808 of the record at paragraph 5 of the schedule. And the court can read all the different components of that financing costs. The 2 points I wanted to specifically draw to the court's attention is 5.2, which is a pro-ratering of the financing costs for the first year after commercial operations of the terminal starts. And it's assumed that the flow through of the terminal will be 11.5 million gallons. And then for paragraph 5.4, which is on page 809, and you'll see there, for every year after the financing fee shall be calculated by determining the annual value of the sum of these components for the upcoming calendar year, dividing the same by the prior year's throughput volume in the developer LPG sales. So the throughput for the terminal is very important in terms of working out when the developer will recover the financing fee and how much. So one can see from that financing model, you're going to therefore build in assumptions in terms of the LPG volume moving through the terminal. If we go back to page 807, there are just 3 elements of the wholesale price that we can, which are useful to identify. The first is the regulatory fee, and that is a charge which is passed on to the government to assist them in regulating the industry. Then we have the G&A fee. That is a fee to provide NGC with funds necessary to carry out their general administrative functions, and the O&M
But
fee.
all of these are under user fee, right?
Yes,
Right. So
Your
who
Honour.
pays, in a practical sense, who incurs the cost of that user fee? So NGC brings in the product from the US
Yes.
at a cost.
Hmm.
Does it add these 4 fees on to that cost?
So it's factored into the wholesale price. So the
Yeah.
LPG comes into NGC, and you can see, actually, if you go back to page 807, small paragraph 2 at the end of the page, every time a transportation of LPG comes into the NGC terminal, BBS, which is the government entity which is responsible for setting the price, and NGC sit down and they work out for this shipment on the receipt what will be the user fees which apply to it. That goes on to the wholesale price, and then anyone who is buying that wholesale price, which as we know is regulated, and we see based on which regulated, will in effect pay the user fees. So they'll pay the price that the LGC was bought plus the user fees.
So when you
Part of the
say
wholesale price.
the wholesale price is regulated,
Yes,
you mean it's regulated in this sense?
after the Act, it's
So that-
regulated in
yeah.
this sense.
Yeah, so it's regulated on a fluctuating basis.
Well, for the financing fee is recoverable depending on the throughput through the terminal. The other user fees, regulatory, O&M,
Fixed.
they're fixed, but I think they're fixed by volume, but it's a fixed price per gallon, I think. So ultimately what then happens is you have the wholesale fee.
Which can fluctuate depending on the markets for importation.
Exactly,
Yeah.
precisely. And then distributors in Belize will buy, if they buy their wholesale from NGC, they will then sell it on, and there's a maximum retail price, which remains regulated separately from the new Act. So
But
ultimately,
is that tied as a percentage increase on the wholesale price? Because the wholesale price is changing, right?
Yes,
The cost from the US is fluctuating.
yes.
The financing fee is fluctuating because that's based on the throughput. The other fees are fixed.
Yes.
So is it that the regulating of the retail price is on a percentage basis of the wholesale price, or is it a standard fixed price?
Your Honour, yes, it's a very good question. I know it's reviewed. I don't know that it's a percentage markup. I think it may be different to that, but maybe I can take that question and then we can supply the
No,
answer
I'm
to
just
you.
wondering.
Yes,
So yeah.
but obviously there has to allow for a profit element if you're buying at wholesale.
Well, that's why I'm asking the question.
Yes.
That's why I just speculated that it
Yes.
may be a percentage because the wholesale price is not a fixed price.
Yes.
Yeah.
But ultimately, the point is that the end consumer in Belize is effectively paying for the user costs because it's passed on to them.
And the whole point of this fee regime, it would seem to me, is to pay back the cost of establishing this facility.
Precisely that, Your Honour. And I just want to show you something important because,
What was the objective cost of establishing this facility?
sorry, Your Honour.
Cost to build this 1.5
So the evidence is that it was 60 million
US dollars.
US dollars. And then obviously cost is a more sophisticated, I mean, the way in which that cost will break down would depend on equity investment, what your financing arrangements are. But what we can see through this legislative scheme is that that has all been worked out on a 15-year term. And
At least 60 million on a 50-year term, secured by different
yes,
forms of security,
yes,
and then paid back essentially by, well, not the import cost, but I guess the financing fee is what is going to have to be tweaked to meet those financial commitments to whoever your creditors are, right?
yes, but we can see that there's obviously some analysis gone into the back of this legislation and assumptions made before it was introduced.
Okay, yeah, good. Thanks.
But there is one point which follows on, Your Honour, which is quite important to understand in terms of the economic impact on the claimant companies. And I think the easiest way to illustrate that, if I may, is to take you to our submissions before the Court of Appeal from June 2023. I hope this is the last document I'm going to have to take the court to. But if you could go turn up the record at page 5057, if the court has that. This is a table which was produced, and it shows the comparison of the breakdown of the NGC wholesale price versus the Tomza wholesale price, if you've got that. And that's been reproduced from customs receipts, which were produced by Tomza when they imported the LPG. And the important point, Your Honours, if you were to go down and you were to see the CIF price, or sorry, the landed cost, I think it's probably the,
Could you remind us of the page, please?
yes, it's 5057,
Okay.
Your Honour.
What are we looking at, the CIF price, the CIF price?
Well, I think the most appropriate starting point probably is the landed cost, because that's the
yeah.
cost at which it comes into the bids. And you'll see for the NGC terminal, I hope the operator can hear me, for the NGC terminal, the landed cost is significantly lower than the Tomza landed cost. And that's not surprising, because the Tomza landed cost is going to take in the cost of the terminals outside Belize and the transportation into Belize, whereas it's coming in the NGC terminal, it's coming direct from the US Gulf Coast. And then what you see is the user costs that we've just looked at added on top of the landed costs for the NGC terminal. Obviously, they don't apply to the Tomza costs. And at the end result is that we get, in this particular example, a smaller amount for the NGC terminal for the import wholesale price than we had for the Tomza. In fairness, we've also on page 5058 given you an example of NGC and Zeta, which is a different claimant company where I think the Zeta wholesale price comes out slightly less. But the short point to make, if you look at the comparison of these prices from an economics perspective, is that they come out broadly the same when you get to the import wholesale price. So what the end consumer in Belize could not do is pay for the project, which is the user costs, and then assume also the costs of the terminals outside of Belize. Once you bring in on a landed cost basis using the old methodology, which is shipping to Central America, trucking it in, you can't then add on the project costs.
Wait, hold on. Let me just be clear. So that
But you-
under the NGC setup, their landed costs are lower. That is landed in Belize, I'm guessing. Their
Yes.
landed cost is lower than, for example, use the Tomza, right?
Yes.
But did you say that when you add on the user costs, what happens? Did you say it's
So-
priced out to more or less the same? Is that what you said?
Yes, Your Honour, maybe I can put it in a slightly different way. The landed cost for Tomza, if you were to take that, there's
Yeah.
no headroom really on that to add on the user costs for the terminal, unless you're going to significantly increase the wholesale price, which would then have a knock-on price for the end user in Belize. The importance of bringing it in by sea was that the landed cost was much lower, so that you had the financial headroom to absorb the user fees for the new terminal to fund it for the end consumer in Belize. So, Your Honours, may I turn to the economic impact on of this new regime on the claimant companies? We make 4 points in relation to this. The first is that the legislation did not prohibit the claimant companies from selling to either its wholesale or retail customers. They were perfectly free to continue to do so, nor did it state that only NGC can supply the customers of the claimant companies, whether wholesale or retail. Nor did it prevent the claimant companies from acquiring LPG. In fact, as we've seen, there was some measure of legislative protection in place for the acquisition of the LPG at a wholesale price because it was regulated. The second point is that, as a matter of fact, the claimant companies did continue to sell to their retail customers, notwithstanding the introduction of the legislation, and they continue to do so today. In fact, in their own submissions, in response to our appeal at paragraph 6E, the claimant companies say that their complaint is limited to wholesale. The third point is that, as a matter of fact, they continue to sell to wholesale customers. NGC, you heard from Mr. Courtney, only sells 2,400 gallons or more. So anything below that, NGC would not sell to the small distributors anyway. In their closing submissions at trial, the claimant company stated that they had lost 45% market share to NGC, but did not identify how that percentage splits between retail or wholesale or either or. The difference from the introduction of the new, from the original Act, was that they could not buy their LPG at a price from their sister companies outside Belize, but had to buy it from NGC at the new regulated wholesale price. They could still sell to their distribution customers, including those to whom NGC was not selling because they were too small. But the problem was there was no profit on those wholesales. And if one steps back, the real loss is likely to have been made further down the supply chain, because obviously the oligopoly is not supplying 93% of the LPG to Belize anymore. The fourth point is, in fact, there was no evidence before the court at trial that the effect of the legislation was to cause any of the respondents to go out of business. Mr. Justice Balkan accepted that 3 of the companies remain very much in business, operating in all areas except that of importation. That's at paragraph 159 of the Court of Appeal judgment, record page 67. One of the claimant companies did go out of business, Southern Choice Butane, but the evidence of Mr. O, who was the accountant for that claimant company, was that the failure of that company resulted from a failure to address operational expenses, which started well before the new legislation. And the transcript reference to that cross-examination is at record pages 4822 to 4825. So we respectfully submit that the Court of Appeal was wrong to find otherwise in relation to that one company. The Section 17 claim eventually articulated before the court of first instance was taken on acquisition of goodwill, but the simple fact is that it follows from what I have just set out. The effect of the legislation was not that NGC acquired or took the claimant's company's goodwill.
Ms. Welsh, this is a really important point because the positions on both sides are radically different.
Yes, Your Honour.
Can you point us to anything on the record that speaks to the continuing sale of LPG to wholesale customers by the gas companies? I'm asking because the respondents have contended in their submissions that they simply no longer supply LPG on a wholesale basis, even by purchasing from the NGC. And so I'm wondering if there's anything on the record that you can point us to that supports the government's contention that they continue to sell to wholesale customers.
Well, Your Honour, the reference I have is the closing submissions dated the 25th of August 2022 at record page 3969, and it's paragraph 127, where the claimant company stated that they'd lost 45% market share to NGC. But as I say, they don't identify. We know that they could continue with retail because retail was unaffected. It's not identified whether that's retail, wholesale, or both. But we also know that NGC only sells over a certain volume. So NGC were not selling below 2,400 gallons.
So is your response then that there is no evidence, but for what you asked of, that they contend that they no longer supply on a wholesale basis? Is it then that there's no positive evidence to contradict that? Is that what you are saying?
Well, I say what their position is, that there was a reduction in sales. And this is really important because it goes to the nature of goodwill, which I'm about to address the court on, because by the time it came to trial, what the position of the claimant companies was that we lost our goodwill. Now, one has to ask the question, what is goodwill as an economic concept? The court has two authorities in the bundle which are particularly helpful on this. The first is the comments of Lord Justice Black and Ulster
But sorry, Counsel,
Yes.
you're going on to the definition of goodwill, which I assure you I'm keenly interested in. But you are moving away from the question of the loss of wholesale customers. So it seems to me that the goodwill, as has been pitched by the respondents, is essentially this is one strand of their pitch, is essentially that unable to import, we were unable to sell to our wholesalers, right? So what I need for you, before you go on to define goodwill, is to clarify for me the point you were making about the wholesalers.
With respect, Mr. Justice Barrow, the goodwill point is absolutely connected to this. And the reason is because that one has to ask the question, what is the property which the claimant companies say has been taken? They say what has been taken is their goodwill. We say, and this is what I was about to come on to, goodwill is not a loss of profit analysis. What was presented to the court, and we know that there was serious problems with the presentation of the evidence to the court, as the Court of Appeal has found, was a loss of profit analysis. A loss of profit analysis is not the same as goodwill. It's simply not the same. It's a different economic concept. And that's the point that I was about to make good. So we accept that the impact of the legislation was to regulate the wholesale price, and that is going to make it is going to have an impact on the profits of the whole sales to wholesale customers, because the new wholesale price includes within it user fees, which the LPG companies, the claimant companies, were paying.
Do they say how many wholesale customers or what percentage of the wholesale custom they lost?
Well,
Do they say what they lost?
Mr. Jasper, if you'll have read the Court of Appeal judgment, you'll see that part of the problem before, which was fairly identified by the Court of Appeal, is that the case was not pleaded or proven below on the question of loss. And what, in fact, Mr. Justice Balkan fairly points out is that in order to assess the property which they said actually had been lost, Goodwill, you would need to have expert evidence on what that is. So, as I say, what they presented to the court below was that they had lost customers. That evidence was riddled with problems, as the Court of Appeal has found. So I don't think that I can fairly suggest to you what the definitive amount of loss of customers was or the reason why, because that wasn't before the trial at first instance a proper basis.
To satisfy my very linear mind, I will take it that what you are saying is that there's not anything which occurs to you where the gas companies point to the volume of or the percentage of wholesale customers that they lost as a result of the legislation. Is that correct?
Mr. Justice Barrett, I've identified the paragraph in their closing submissions where they identify 45%, but we can't say whether that's wholesale or retail.
Right. So 45%, but not identified as wholesale.
Sorry.
Not identified as wholesale.
Well, it's not identified whether it's wholesale or retail, and we
Right.
know we were doing both, so I can't. I don't
Therefore,
want to
it is not
misrepresent.
identified as wholesale.
Yes, yes,
It is identified as a general loss.
generally,
Right.
yes, Mr.
Okay, as a matter of practice to common sense, they would have lost the wholesale market in selling LPG in units above 2,400 gallons. Because
Well, not necessarily, and this is why Goodwill is so important.
yes,
And it's really critical that we go back to Goodwill, because that's what the case was, that the property which had been taken as Goodwill. So Goodwill is, and I'm sure the court will be familiar with this, but it's not a loss of profit analysis. It's a more intangible analysis. It's the expectation that old customers, and I'm reading from the Ultra Transport case, will continue to do business, and that new customers may be attracted by reason of repute in which the undertaking had obtained.
I'm following you, counsel, but I think the argument is that those customers who would have bought from them
Yes,
as wholesalers
yes.
above 2,400 gallons,
Yes.
They have lost those customers.
Well,
They've
they-
lost that business.
Wouldn't necessarily on a Goodwill analysis, and this is the point that I'm making. In fact, the
Yes.
Goodwill analysis goes against them, because if Goodwill is a question of business repute, so let's say, to give you a non-LPG example for a moment, let's say that I have to decide whether I'm going to bank with Belize Bank or Atlantic Bank. There will be things that operate on my decision, and that might be how responsive they are to customer complaints. It might be what my general perception is of their trustworthiness. In the LPG market, Goodwill may be affected by how quickly the LPG distributor gets it to me. I need my LPG within a day, or they're going to get it to me in a day, and I'm going to have to wait a week. The LPG that's delivered, what is the...
But how does it work in practice? The wholesaler would go to the terminal and collect the tanks, whatever, from the National Gas Corporation. Now, if that is one route of getting your wholesale quantities,
Yes.
and the other route is to have the gas companies go collect it and then deliver it to those wholesalers, then surely it would not be economically feasible for that to.
Well, Your Honour, I would accept that there was no, that the impact of introducing the wholesale price meant that wholesales were less economically attractive to the claimant companies.
That we can agree on.
I would
yes.
accept that.
Yeah.
But the property which they identified in the court below is Goodwill. That is a different analysis to a loss of profits analysis. The question that you ask yourself when you're performing a Goodwill analysis is you do analysis of the business as a whole, and there's another authority which the Attorney General has put in their submissions, Inland Revenue Commissioners and Muller. That is a case which is looking at the assessment of goodwill from a tax perspective, and it ties goodwill to an entire business. So if you lose your entire business, or if you're valuing a business, you would value the assets of that business, but there's an intangible element on top of that, of those assets, which looks at the question of what the attractiveness by repute is of that business to customers. So if I acquire the name of Belize Bank, how many customers are going to follow Belize Bank? That's what goodwill is as an analysis. And what Mr. Justice Balkan fairly accepted was part of the problem with the damages analysis, is that they had not identified essentially what loss had been caused through loss of goodwill. And I would go further than that. They had not identified what the loss of goodwill is, because you only lose goodwill when you lose your entire business, and that is an assessment. The assessment of that property would require expert analysis. It's not as simple as just showing that you've lost some customers.
And you say that there was no such expert evidence and therefore not proved.
Yes,
That's how I understand your
Your
case.
Honour.
So whether they had in fact lost substantial wholesale business, you say that does not affect the proof to the loss of goodwill. Is that how I understand?
Yes.
At this stage anyway.
Yes, yes, Your Honour. Yes, we would say that it was not identified.
So just to be very, very clear, you're saying that the only instance where the goodwill is lost is where the business is lost,
When the entire business is lost.
not in Total
Yes.
Fisheries case.
Yes,
for
you don't
example.
partially lose goodwill. Goodwill is not divisible by part of the business. It's the entire business. It's lost, or more usually when it's acquired as part of an acquisition, then you value the element of goodwill. It's what you're prepared to pay above the assets for the repute of the business. So we just make some short submissions on goodwill. We also say that there's no goodwill in the importation. There's no business in the importation of LPG anyway. Importation is moving the LPG across the border. The claimant is not selling it as an exporter across the border to an importer. So we say there's no importation in the
Is there
sourcing of
anything of
LPG.
relevance to that point in the license granted to the gas companies to import?
Absolutely, Your Honour, because we know that the licenses in this case, prior to the introduction of the legislation, were short-term licenses. So we would also, and we've set this out in our submissions, I won't go to it, rely on the fact that there could be no expectation beyond that short-term licence. I think the example was given by Mr. Justice Balkan of the Belize Bank. Belize Bank may acquire goodwill, I don't absolutely accept that, but they're licensed. And if that license was taken away on the terms of that license or not renewed, the state is not liable for goodwill attached to that business.
I was thinking in terms of the content of the license. Does it mention retail, for example, that the importation was for retail purposes?
It does, Your Honour, it does mention retail, but you have to, well, first of all, I rely by the duration of the license. But secondly, the question is, if you're identifying goodwill, the goodwill is not in bringing the LPG into Belize, it's the attraction of the customers, who in this case would be the retail or the wholesale customers.
Could you clarify something for me?
Yes, Your Honour.
In the Attorney General's submission, they make the point that there was only one license granted to these businesses, and they put in lovely bold, retail, fuel distributors, LPG or whatever it is.
Mm.
So they're saying only one license, retail. You are now saying that there was a license for importation. Is that the fact? Is Mr. Courtney's submission correct? Only one license, retail? Or are you, as it were, modifying that and saying there was also a license imported?
I'm not suggesting that there's a separate importation license. There's one license.
Well, you need to be careful. You're undermining his thesis.
No, well, with respect, I don't believe I am, because,
Okay.
yeah. The short point
I
is
want to
that,
assure you the reason why I asked is because I thought that is what you were doing. The
Okay.
reason why I asked. So I'm glad to know I got it wrong.
Well, I would hesitate to suggest that you have it wrong, Mr.
Thank you. You're kind.
Mr. Barrett. I'll move on very quickly to deal with user costs.
But before you move on, well, you say there's no goodwill in the importation of LPG. If goodwill goes to reputation around service and quality of product,
Sorry, Your Honour, I'm struggling to hear you. I think.
you said that there is no goodwill in importation of
Yes.
LPG.
Yes.
There could not be. But
Yes.
if goodwill goes to your intangibles of quality of product,
Yes.
service, and that other basket of things that you said were the intangibles, why is importation why is it that importation cannot be part of what is a consideration in assessing the whole business's goodwill? Because it's a whole business. I bring in a product, and then I either wholesale or retail a product. As an importer, wholesaler, retailer, it's one business I'm doing. My goodwill depends on the whole package.
The quality of the product, I think, is what you're.
Correct.
Yes.
But also the service parts of it, not just the quality of the service. In other words, suppose you want to buy LPG, that's this case, but this restaurant needs £100 every week. Then the import side of my business can impact my goodwill in terms of customer satisfaction that it gets this £100 gallon of LPG every week.
Yes. Your Honour, I see the point you're making. My response to that is, first of all, I go back to the point that goodwill is a concept which is not divisible.
I accept that.
And secondly, on the facts of this particular case, the purpose of the regime here was to improve the quality.
No,
Yeah.
I'm on your submission that there could be no goodwill in importation.
Yes.
That's what I'm interrogating. I understand
Yes.
what you said before.
Uh,
Is that a correct statement in a whole business that imports a product and retails or wholesales it? That's what I am struggling to understand, because your intangibles of service, customer service, quality of products, all of those things in a business of import retail,
yes.
I am struggling to understand why the import side is just cut off and says it cannot impact goodwill. I just don't get it, to be quite frank.
Yes, no. Well, Your Honour, I can see that the point that you're making. What part of the difficulty is that we don't.
I'm speaking conceptually.
I know you're speaking conceptually. That's a point that I would like to think about and come back to. But I think that would, if anything, have one would have to look at whether or not, as a matter of fact, it had an indirect impact.
Surely
as
you
I
would
say,
agree that quality of product, service, in the example I gave with the £100 cylinder, that
Yes.
the import side of a business could have arguably some relevance to that, wouldn't it?
well, it
If I dare say, I think that should be a matter of common sense.
Yes,
It's not a
yes.
question of law.
No, I can't. Your Honour, I can't submit to you that has no relevance. But obviously, I rely on the facts of this case, and there's no suggestion on the facts that it did have a relevance.
All right, thank you.
I think, Ms. Welsh, we're coming very close to.
Yes, I had
Thank
two.
you,
Do you want me to? I have two short points to deal with before I sit down, and
Yes, please, yes.
yeah. The first point I think I can take very quickly is the user costs point, and that is because you've seen the way in which the price was built up post the legislation. Mr. Justice Bolkin described that argument as a bewildering argument in paragraph 47 of his judgment. He said what was being complained about here was a monopoly, and those conditions must come within section 17.2. And nowhere in this scenario have user costs arisen as an issue. And we simply say respectfully that analysis is wrong, because what one has to do is assess the economic impact of this legislation on the claimant companies and identify what property has been taken. I've already made my submissions on Goodwill. If we don't say any property is taken, but if the court were to find that anything has been taken for Section 17(1) purposes, what has given rise to the company's loss on a profit analysis basis, which was presented to the court below, is the statutorily mandated user costs, which were necessary to fund the project. We saw that when we looked at the difference between the NGC wholesale price and the Tomza and Zeta wholesale
Sorry,
price.
so what you said, which cost you say it was?
The user costs.
The user fee cost.
User fee costs.
Okay,
Yeah,
right, right,
by which I'm defining anything other than the landed cost price. And we say the incorporation of these costs into the wholesale price was meant, in effect meant that for wholesale sales, the claimant companies were no longer able to obtain a profit on sales. But that loss is a levy imposed by the state and therefore is capable of falling within
So
Section
that falls
17.
within one of the limitations. That's the
Exactly.
argument on that.
Yeah. The final point I was just going to make very briefly is to deal with the Amendment Act. Mr. Courtney has already been asked
But
questions.
hold on. Why I also look at that section. What section 17 was?
17.2A.
Yeah. Why is a user fee that is put on in a public-private commercial enterprise to recover capital expenditure in the establishment of an entity, government tax or rate?
Because in this case, it eventually becomes a state asset. So what you're doing is you're paying for the funding of the construction and operation of an asset, which will become a state asset in 10 years' time. So in the same way as government is able to recoup financing through any other means, this particular project, the financing was achieved through a PPP. So that is why we say if there's any loss here, it was the fact that they had to pay the user costs, and that's a tax rate or due.
Okay, yeah, thanks. Yeah.
Just finally on the 1.5, I just wanted to make 2 points very quickly, or maybe 3 points. Sorry, 3 points with the court's indulgence. I'll start at the back. There were 2 conditions which were attached to the levelling of the playing field with the Amendment Act. So if you could either buy your LPG from NGC, as we saw, under the original Act, or under the Amendment Act, you could ship your own LPG in and you could store it with NGC. And the complaint which is made is that that would have put the claimant companies at the whim of a competitor. That's why they say that that condition was onerous. And I just point out that Mr. Justice Balkin said, for that reason, because of the uncertainty and vulnerability for them, it did not pass the proportionality test, and that's at the judgment at 113. But we respectfully rely on the finding of the first instance judge at page 42 of her judgment, page 5028, which said that she had not heard any arguments or seen any evidence to convince me on a balance of probabilities why the second option is not viable for the claimants or any other potential investor in the LPG industry in Belize. So we do very much say that that second option of storing it and paying for the use of the terminal was one which was viable in these circumstances, and that's what the first instance judge said. The second, 2 short points in relation to the additional 1.5. The point was put to Mr. Courtney that why do you need an additional 1.5 capacity? The point that we make in our submissions and which we rely on is that if you were to have a smaller terminal amount, and I think that Mr. Mendes putting across to Mr. Nicholson 400,000 gallons, then this would mean smaller construction and operating costs, which would be factored into any user fees in this case, and that would undermine or put at risk the project which has already been established under the original Act. And the second is that the 1.5 million US gallons condition is always also a forward-looking condition. We've already heard that by the time of the second hearing in August 2022, 40 million US gallons was being imported into Belize. That would go up. Whether or not the claimant companies or indeed any other investor in Belize could meet the 1.5 would have to be decided when a project was put to the government of Belize. But even the first instance judge said that the price tag of constructing such a facility may be onerous for the claimant companies based on the evidence of their financial circumstances at the time. And that is Justice Arana's judgment at page 16, record page 5002. So the other entrants into the market may not have the same difficulties as the LPG companies in this case had on the facts of their particular case. They couldn't sustain the proposal.
Yes, thank you very much. Thank you very much for those submissions. You did go a little bit over your time. I'm sure that the opposite side would have noticed that, so we will keep that in mind going forward. We are going to rise now for about 15 minutes, which means that we'll resume 11:42. I make it. Thank you, Council. Extra one, so just in case. Okay, so before we resume, may I welcome students from the Hugh Wooding Law School and the UWI Faculty of Law. You are most welcome. Thank you for being here. Counsel?
Your Honours, can I just take you to our skeleton argument of October from part C and pages 8540. And can I just summarise the key points I wish to make? The issue, of course, is whether there's a taking for the purposes of section 17(1). And our first proposition, which you've already heard my learned friend develop, is that there was no taking because no goodwill was taken. And you have our submissions on that. Our second submission is that there was no taking because the legislation is regulatory in character. And where the legislation is regulatory in character for a public purpose, then it's not regarded as a deprivation of property or a taking of property for the purposes of section 17(1). The third point we make is that if the test is, as Justice of Appeal Balkan found, whether the regulatory provision went too far, then it did not go too far. And we've set out in paragraph 36 of our October skeleton the reasons why we say it did not go too far. That is the stage, if we get to that, where the issue of deference would come in. And I know that, Your Honour, the President raised the issue is about the socio-economic phase. Can I just make these brief points? My own friend, Mr. Courtney, has already indicated what our position is on this. But firstly, can I just draw attention to Lord Reed's statement in the case of SC at paragraph 144. You have it in our bundle at page 514 of that. But I can just quote what he says. He said, the court should, I quote, accord appropriate respect to the choices made in the field of social and economic policy by the government and parliament. And of course, it's particularly important where it's the legislature, and that is picked up by Lords Neuberger and Lord Mance in the Ararangi case, which we have at, it's set out in our reply at page 11192, paragraph 30. And there they said, so far as the decision maker is concerned, in this case it was Parliament, the legislature is entitled to a wider margin of judgment than the executive. Unlike a person exercising delegated powers, the legislature has a wider range of options open to it, and as a result of it being elected, it enjoys democratic legitimacy and has direct democratic accountability. Further, as a practical matter, it is normally, at any rate, difficult to identify the motives of the legislature, given that different members may have different reasons for voting in the way they did, and in relation to a number of bills. And we've set that out in the January reply at paragraph 30, page 11192. And of course, Justice of Appeal Balkan himself recognised at paragraph 35 of his judgment that the special case of what he called areas of policy involving complex financial or economic matters are ones where the judiciary is institutionally incapable of second-guessing legislative decisions. Now, Your Honour, I would respectfully submit that my learned friend, Angeline Welsh, has just given an example of where there was a second-guessing. The first instance judge, as she pointed out, made a finding at page 5029 that there was no, she said, I've heard no argument and I've seen no evidence as to why the option of storing LPG in the terminal is not possible. So that's a finding of fact and value judgment by the first instance judge. What does Justice of Appeal Bob say about that? He doesn't even say, well, I realize there's a finding of fact that we should respect unless we've got a reason to. He says this, and it's paragraph 163 on page 68. However, this is the second sentence in. However, as emerged at the trial and on appeal, this was ineffective as the conditions themselves were so unattainable or unreasonable, the monopoly remained. The requirement of constructing 1.5 million US gallon terminal is a gargantuan undertaking beyond the reach of any company not enjoying the same benefits as the NGC. The alternative of passing all imported LPG through the latter's terminal is equally unpalatable. What's the concept of unpalatability as a test of constitutional review? As it would subject the claimants to the uncertainties and vagaries of relying on their competition, where they didn't even apply. That's the point. They never made an application for this second alternative. So we say when the legislature has put forward a solution, either if you want to do it so that there's a level playing field, apply for a license and the condition of the license will be you build your own, or store it in the terminal. And the single judge hearing the evidence has said, I've heard no evidence and see no argument why they can't do this, why this is unviable. The reasoning of the appellate court on review of Parliament's presentation of choices is, well, it's unpalatable. We respectfully submit that that doesn't show deference or respect to the legislature in an area of social and economic policy at all.
Sorry, what page was it again? That or paragraph? I have the judgment here. What paragraph?
It's paragraph 1663, my lord. Does my lord have it? Page 163 at page 68 of the record.
No, the paragraph number in the judgment. Vulcan.
Yes, it's paragraph 163. 163, my
Gotcha.
lord. Just
I got it. Thanks.
does your lord?
Yeah. Yeah.
Sorry,
I have it. No, yeah.
I have old-fashioned. So does your honour see the?
I thought you said 1663. You repeated the 6. So I was.
I'm so sorry. I apologise. Anyway, there it is.
Yeah.
It's 163, my lord. But
I am on the same page and paragraph as you.
okay. So that's just by way of opening. But
Okay.
the court has our submission that there's no taking because no goodwill was taken, and certainly no significant goodwill was taken, given that this is not a case where there's an obliteration of the trade, in the word of Manitoba Fisheries, but where on the court's own findings they continued in business. But the further point that I respectfully make is that the right to compensation under Section 17 is not engaged here because the relevant legislation is of a regulatory nature and it's regulation in the public interest. We've referred the court to Lord Hoffman in the Great Bay case, and we've set that out in the skeleton argument at page 8542, where he says these principles do not require the payment of compensation by anyone whose private rights are restricted by legislation of general application, which is enacted for the public benefit. You have that at the bottom of 8542 in our skeleton. And we have relied also on the principle that where there's no more than regulation in the public interest, then there is no taking within the meaning of Section 17(1). And we say that that was the case here, and certainly it was the case in the Amendment Act. If one looks then at our paragraphs.
Mr. Fitzgerald, I understand the jurisprudence. On the facts of this case, the legislation merely regulatory when it is also creating a public-private business that eventually, over 15 years, 10 years now, the state will acquire? And so that, is this in the category of purely regulatory law when it has that additional element to it? And so, for example, as Ms. Welsh showed us, there are pricing regimes and calculation regimes in order to recoup capital expenditures and all of that. And so yeah, could you just,
Well,
are there any cases with that additional kind of flavor that have been categorized? I'm not preoccupied with if there are other cases. That's more an aside, but
yeah, no, well, my
I'm
lord,
just trying
to
to,
try to address the issue of principle, if
Yeah.
we look at the Amendment Act,
yeah,
then we say that was regulatory. It was saying if you want to import, you could do it. And this is general. It's addressed to the world as it were. You could do it.
you mean that aspect, because the Amendment Act
Yes.
does not denounce the creation of the capital facility, so it's a whole package.
Yeah.
So to say that, when you say the act, I'm assuming you mean the act as amended,
Yes.
the
Yes.
entire package.
Yes.
So that's my question. My question is this properly an act that we can, as amended, that we can describe as regulatory in nature in the classic sense?
My lord, firstly, it's introduced. Can I just try and characterize it in this way?
Sure.
It introduces a new regime for the importation of LPG. That's what it does. And that is very much like the Society United Docks case, where there was a new regime for the importation of sugar with the bulk terminal. And as at the same time, there was, in fact, a monopoly imposed, and Lord Templeman in Society United said that the objective of it, I can just give you the quote, the objective of it was not to ruin the dock and stevedores companies, but to preserve an efficient sugar industry in the national interest. That's at page 603F. So, well, I'm not trying to dodge the question, because I understand your lordship's point entirely, but this is one of those category of cases like Society United Docks, where what is being done is to introduce a new regime for importation. And that is, in that sense, it's regulatory. And of course, the utility.
So would it be,
utility
would it be fairer, maybe more appropriate to characterize it as an act that has regulatory aspects, as opposed to saying that the act is regulatory?
Yes.
There's a nuance but significant difference maybe in that distinction.
My lord, yes, I think that may be correct. And in that respect, it's like the Society United Docks case.
Fair enough. I get the analogy then.
They bring in a bulk terminal. As a result, the stevedore companies go out of business. They say we want compensation, and Lord Templeman says there is no compensation for progress, as it were, for progress and modernization. That's exactly what's happened here, that a new regime has been introduced in the public interest, and Mr. Courtney's explained the importance of that to Belize to be able to do these kind
But
of
the critique, therefore,
yes,
insofar as the critique, so that if we nuance the description as an act that has regulatory aspects, insofar as the critique focuses on a condition for the establishment of an equivalent facility, i.e. the 1.5 million gallon facility, yeah?
yes.
Is that aspect, would you put that in the regulatory category?
Yes, it's it's saying if you wish to import
You must have this kind, that the regulation is you must have this
You must
equivalent
have it, yes,
facility.
and anybody, I mean, I'm not trying to be rude, but
You can be if you wish.
no, not to you, but to the respondents. They're entitled to, if I can moan and say, why shouldn't things carry on as they always have done? The answer is because it's necessary sometimes to modernize, to change in the public
Yes, but
interest.
are they saying why should things carry on? To say why should things carry on, I suppose that may have been a challenge maybe to the original act. I don't know where we'll go with
Yes.
that. But if what they're saying is that it is the 1.5 million gallon facility aspect that is oppressive or disproportionate, depending on if we reach there, that's not necessarily anti-progress. It's sort of a kind of a substantive equality position. We all can't start where you start. You have your facility. We understand your regime, but to have a level playing field is not equality in sameness. It's equality in a fair opportunity, which is, we understand what you want to do, but 1.5 makes it out of our reach and therefore so exclusory that it is disproportionate.
Well, my lord, again, one comes back to the test. What are we asking? What's the court asking under 17.1? Is there a taking,
Yeah.
or is there the introduction of a new regulatory regime with regulatory connotation? What are we doing?
Yeah.
There may be other areas of the Constitution, as your lordships referred to, equal treatment or something like that, right to work, which we say doesn't apply. But this 17.1 is this the introduction of a new regime, new modernized regime that doesn't give rise to a complaint that you have taken my property? And Society United says that is the situation where there's modernization, which has adverse effects. And the intention is to preserve an efficient sugar industry in the national interest, or to keep to introduce a new LPG industry in the national interest. That is not a taking. Maybe all sorts of other things under other sections of the Constitution, but we'll deal with those as it were in turn. And my learned friend, Mr. Courtney, suggested it might be analysable under Section 3 rather than Section 17. But we say it is not a taking for the reasons given by Lord Templeman in Society United Docs, and in the cases of Great Bay, where Lord Hoffman says regulation in the public interest does not give rise to a taking for which compensation is due. And of course, in Campbell Rodriguez, where Lord Carswell says that it's not a taking where you introduce a new regulatory scheme in the public interest. But my lord, I don't know whether that's a complete answer to your lordship's point, but that's what I respectfully submit. But can I then take the alternative? Because what Justice of Appeal Balkan said was we've got to bring in proportionality. If we're right and it's simply not a taking, you don't bring it. You don't get,
because there's no breach of right.
Yeah,
You don't get past stage one.
You don't exactly.
No, I get
And
it.
so all his stuff about there's no 17.2 thing here is irrelevant. You're still on 17.1.
Step one is,
You haven't got-
is there a breach of a right?
Yeah. Have you taken anything?
Well, that is what would constitute the breach under 17.
Yeah, yes, absolutely. Yeah. Have you taken anything? And then it's but
Did you give us, Council, sorry to interrupt, but did you give us a definition, a conceptual way of looking at what is a regulatory activity versus what is sort of legislation which acquires property?
well, my lord, we have attempted that in our reply.
Yes.
I don't know whether we've done it very, but we have in our reply we have sought to characterize why this is. And can I just give you the formula? But just off the top of my head, what I would respectfully submit is, if the new measure is intended to introduce a new regime of a regulatory nature or with regulatory in the public interest, rather than simply
Which affects
the
the population generally.
yes, which
would you
affects,
say?
yeah, well, which affects all those affected.
Affected.
Yes, yes. I mean, certainly. Yeah, then it's regulatory, but Society United, it obviously was not a case where it affected it had consequences for it. But look, if we look at this situation, Justice of Appeal Balkan says this is just like a bank getting a license. These licenses that were being given were given for 35 days before. 35 days. Bankers don't get licenses for 35 days, they get years. It's in a highly volatile, vulnerable area involving a crucial asset. Everybody's homes depend on this. It's quintessentially something where the government has a public interest in regulating it. There might be all sorts of reasons why you don't want to depend on lorries coming over the border from Guatemala, not least the dispute in the background. These are reasons of national security, of storage security, of avoiding dangers, all of which the Parliament's, the legislature's entitled to look at. That's why we respectfully submit this is a regulatory or new regime introduced in the public interest. And that was we submit the purpose of the legislation. I think, my lord, I'm just trying to see where we try to characterize it in the reply, but we certainly do in the skeleton, the first skeleton in October, we say that central question is how does the court, this is at paragraph 27, assess whether legislation is or is not a taking. And then we put at paragraph 20, legislation tested against both its legislative intention and effect, which is of general application and controls property, is regulatory nature. So that's the passage in bold. It's you look at it, the intention and effect of general application and controls property. It's regulatory in nature. And that's the Society United, Great Bay, and Campbell Rodriguez. But, Your Honours, can I just move on from that? If what Lord Carswell says in Campbell Rodriguez, and that has obviously picked up at paragraphs 17 and 18 of the judgment in this case, what he says and what Justice of Appeal Balkan adopts is, unless the regulation goes too far. Now you have our first submission, which is you don't even get into that if it's regulatory. But if you're asking yourself the question, did it go too far? Can I just draw your attention to what the passage we've set out at page 8544 in the skeleton at 28.4, the Allahabad High Court in All UP Stamp Vendors Association, where it says a business or trade may become unprofitable or unviable on account of various factors, such as the advent of technology, change in consumer preferences, entrance of new competitors, a policy shift of the government aimed at subserving a larger public interest or security of revenue. Well, we're dealing with a policy shift of government subserving a larger public interest. But in the end, these are mere vagaries of trade which cannot be recognized as constituting the infringement of a fundamental right to carry on that trade or business. Now, that's in the context of the right to property, but it's just as apt in our respectful submission to deal with this situation. And so that's the first submission we make. But if we go to the question if the test is, does the regulation go too far? Does this go too far? Then we would invite you to go to paragraph 36 of our October submissions, where we make a number of points. And those points are, the government was and is entitled to regulate all imports. Now, I know the Frank Hope case comes from what my learned friend understandably describes as a dark hour of Caribbean history. But the point made there that there is no constitutional right to import remains valid. There is no, and so thus the claimants, we say, had no expectation other than to have the issue of licenses to them considered in accordance with the government's existing practice and policy. So one's got to look at it. This is about something. Look at what President Trump's doing in the US. Tariffs and imports are quintessentially a matter of public policy and national policy, whether you let things in from abroad or not. So that's the area we're dealing with. Secondly, they also could not expect that this practice and policy, which would not be subject to change if the government changed its policy in keeping with its perception of the public interest. Thirdly, there were disadvantages to the existing practice and policy, and these include the oligarchic control of the Zaragoza family, the lack of in-country storage facilities, the lack of quality and compliance, the health and safety risks, and those disadvantages were set out by Mr. Trejo and Waite in detail. And fourthly, there was a clear public interest in the establishment of a new import regime that guaranteed energy security, proper storage of gas supplies in Belize itself, quality control, and a feasible system of checking compliance in one place. And that was what lay behind the introduction of the LPG Act, the original act. And then, of course, there's the fact that the Amendment Act sought to reduce the impact of the new regime, and indeed the court recorded that fact in deciding not to give vindicatory damages. I think it's at paragraph 159 of the judgment. Can I just check? Where they say, yes, 159. It wasn't from any improper motive.
Mr. Fitzgerald, I mean, I suppose it's a curious question maybe, but if this was, the act was completely regulatory and therefore outside the purview of any taking, et cetera, why the need to amend it to mitigate impact? As a question of law, we would never reach there, would we?
Sorry, what?
As a question of law, we would never have reached there. This was done.
No, well, my lord.
If you are right in what you've said already,
Yes,
then
absolutely.
Yeah,
Well,
it follows, doesn't it?
Our respectful submission is
Not necessary, but done out
was
of.
not necessary, but and one of the reasons was to introduce, because everybody can apply for a license.
You mean to put gas in to import,
Yes,
into
to
NTC.
import. One of the reasons was to introduce a uniform system so that anybody could say, I apply for a license to import, and they would all be considered in accordance with a particular test applicable to all of them.
But none of that was necessary.
None of it was necessary. If
On your construct, the state is entitled to regulate an essential product, NGC, to make sure supply lines and quality, and that is outside the
Yes,
purview of the Constitution.
Absolutely, my lord. And if they were to say to the gas Tomza people, this is very regrettable, we're very sorry, but this is national policy on an economic social matter which is within the legislative thing, that's it. We respectfully submit that would not be unconstitutional. But the fact that they have introduced the Amendment Act obviously even reduces any area of complaint, because what it does is to say anybody can apply, but there are these onerous.
But it almost suggests that they were considering impact and proportionality, weren't they?
Well,
with the
the
amendment.
legislature can do what it wants.
Yeah, all right.
But the question is whether this court can tell them to do it.
No, point
And the legislature is perfectly entitled to say, well, maybe that's a fair criticism. We're going to improve the situation. But the question is, given the deference, and this is not about some subservience to the executive, this is about respect for the responsibilities of the elected representatives of the people. That's their decision. But my lord, I say the Amendment Act makes things better, because
Well, your real answer is it doesn't matter.
my lord,
On the theory of your argument,
yeah, I accept.
it doesn't matter.
I accept that, my lord, and
Yeah.
that is our primary
Yeah.
submission. That is
Okay,
our
good,
primary.
understood, yeah.
And so we then say at paragraph 38, stepping back, whatever precise test is applied, there can be no doubt that both the LPG Act and the Amendment Act serve the overall public purpose of securing the supply of LPG by sea. This ensured stability and security of supply of LPG to Belizean customers. And we make the point, 3 of the companies remain very much in business. The other one is only failed for reasons unconnected with this provision. So we say that for those reasons, there was no taking under section 17.1. My lords, just to deal with 2 cases relied on by my learned friends, the Manitoba Fisheries and the Ulster Transport, and I know the court's well aware because you've already referred to it. In the Ulster Transport case, which of course was an ultra vires challenge under effectively a constitutional provision and the Northern Ireland Act. In that case, the business was a business of furniture removal, and it was the James Brown company that had that business. And what was said was that the intention of the Ulster Corporation in devising the new legislation was, I quote, to capture the prohibited business for the Ulster Transport Authority without compensating the owners. So the core activity of the complainant company, which was furniture removal, and which gave rise to their goodwill, what they promised to do to their customers was to remove their furniture, not to give retail sale, but or wholesale up to 2,000. But the whole of their business was taken over by the Ulster Corporation. And although Justice of Appeal Balkan said he wasn't going to pay much attention to the Ulster case, it is cited subsequently in cases throughout the Commonwealth. But we say it's distinguishable. Secondly, the Manitoba Fisheries case, which again my learned friend relies on, in that case, it removed the whole of the business of the claimant companies, because it produced a monopoly on exporting fish, a total monopoly. And we say that it was described as a case where the effect of the legislation was to obliterate the entire business of the claimants. By contrast, we say that's not the consequence here. There is the consequence is that they can, under the Amendment Act, apply for a license. They can buy their LPG from the bulk terminal and provide it to their erstwhile customers, who they continued to serve. I think they said 45% had gone. The other 55% remains. They're not obliterated. They're in action at this moment. And they can also store their LPG in the construction terminal, which the trial judge found was a perfectly viable alternative, or hadn't been shown to be an unviable alternative. But this is not obliteration.
The only thing that bothers me about that latter option, counsel, is that they would be storing their imports with the NGC in a completely unregulated environment. How would they be assured, for example, that the NGC would allow them to store the quantity that we should store?
Well, that hasn't we haven't got to that because they never applied to do it. But I mean, that would have to be worked out by agreements, obviously. But the
Yes, but it's being worked out by agreements in an unregulated environment.
well,
So
unless there's
the NGC has, on equal bargaining power in that circumstance, wouldn't you say?
well, there would be they'd have to pay the user fee, which would be regulated.
Yes.
So that's subject to regulation.
User fee is.
Yes. But this is I know it's only 25% publicly owned, but it'd be, to that extent, it would be a public authority subject to review.
Yes, but I don't want to get away from the point about the availability of the storage area in the terminal. I mean, that is not something that can be guaranteed to the gas companies, is it?
Well, it'd be wholly unreasonable if they didn't, given that that's stipulated in the legislation, that they have the power to do it. But Arana J's finding was it has not been shown to be unviable because they haven't even tried. They're just saying it's unacceptable to us. So what we're saying is there's no attempt even to adapt or adjust to the new regime.
Is the NGC a public authority subject to JR?
Well, my lord.
No, I'm asking that because
Yes.
of I suppose what you said just triggered it. I don't want to go too far on it because I understand that's not what you hear about. But the reason I ask is this, because then it could mean that if it was that they made an application, for example,
Yes.
to store, get a license, and there was a refusal or denial,
Yes.
then the decision could be subject to some sort of review and have, when I say regulated standards, the standards of reasonableness and rationality and so on, you know what I mean? But anyways, yeah, let's press on.
Well, my lord, that's the submission. That's our respectful submission that it would be a public authority and it would be susceptible, and the user fee is governed. And as Arana said, they haven't even tried. But and to just say it be unpalatable is a rather strange language of review before striking something down. The original, so under the topic that the original legislation does not go too far, we do make the point that to the extent that the Court of Appeal said the justifications had to be under section 17.2, that must be wrong. You don't get to 17.2 until you've decided that there's been a taking. And if you look at 17.2, it's a very restricted group of circumstances in which, despite the fact that there has been a taking, that taking possession of the property is excused from condemnation under section 17. But our question is, has there been a taking, not whether despite the taking there has been there's a
But I
ground.
think Ms. Welch argues that it is excused because of 2A, right?
Yes, absolutely. Well, we do submit that.
If
too.
we reach there.
Yes, if we reach that, we do say that. But if you look at the others, they're not exhaustive of the sort. I mean, supposing you did it for reasons of national security, that would undoubtedly be a justification that would have to be taken into account if you're deciding whether it goes too far. But it's not one of the enumerated grounds for non-invalidation at 17.2.
I think we understand your point, Council.
Thank you very much. Well, then, can I? So then we say the Amendment Act does not go too far either, and we pray and aid the fact that there are a number of options available, as my learned friend has.
So just to draw a line under this, you did say that even if there is no taking, there could possibly be a breach of Section 3.
Yes, and that's
arbitrary.
Yes. That's what my learned friend Mr. Courtney has put forward in his skeleton.
Yes.
And he's cited a South African authority on that issue.
Okay.
But at least that would be governed by principles, obviously, of proportionality. Then, yes.
I see. Okay.
Then, I think, given the time, can I just deal very briefly with the right to work?
Yes.
And we basically we deal with it in our perhaps best in our reply, can I just make these submissions? If we look, firstly, the first question is, does the right to work belong to individuals or to companies and individuals? And our respectful submission is, if you look at the language of section 15.1, the first limb confers the right. No person shall be denied the opportunity to gain his living by work which he freely chooses or accepts. Now, only an individual can be described in terms of an opportunity to gain his living by work. And these are the words taken from Article 6.1 of the UN ECOSOC law, which we provided you with, verbatim, the opportunity to gain his living by work, which he freely chooses or accepts. That can't be a company. But that is the defining limb. What you have after that is a particularization of the defining limb. So only an individual can be denied the opportunity to gain his living by work, which he freely chooses or accepts. Couldn't be a company. And then you say they particularize that, whether by pursuing a profession or occupation, which is obviously only can be an individual, or by engaging in trade or business. But we're particularizing what is in the first limb. And the only thing that one can do then is to say that engaging in a trade or business is by an individual. You can't suddenly expand the architectonic right conferred in that first limb by saying, well, companies can engage in trade or business too, so we'll expand the meaning of the first limb. And so that is our submission. On the plain words of section 15.1, a company does not qualify. And my Lord, I just because we have my Lord Justice Peel Jamidar here, can I just say in the Sanatam case,
Yes.
What Your Honour did was to say that the first question is whether it can be shown in relation to a particular right, that by their nature, they're capable of enjoying, in the case of Trinidad Constitution, 4H rights, and are also entitled to protection for breaches of the same. And so, again, Your Honour focused on the question, you look at the particular provision and you see whether by its nature it's capable of, the person is capable of enjoying that right. Now, it's accepted that property, the right to property can be enjoyed by a company by its nature, but we respectfully submit that that's not the case there. And it's no good in our respectful submission just taking something out of context from another case, saying, well, sometimes person can mean company. You have to look at the particular provision and how that particular provision should be interpreted. And if I can just expand on that, that's exactly what was said in the Antigua Times case. In the Antigua Times case, Lord Fraser said, you look at this particular provision, and obviously only an individual can be tortured, only an individual can be arbitrarily arrested. And then you look at the 15.1, only an individual, we say, can have the opportunity to gain his living by an occupation that he freely chooses. That's our respectful submission, that the language itself compels the conclusion that this right, borrowed from Article 6.1 of the ECOSOC, which is only for individuals, is conferred on individuals and not companies. And that's us. But the second point is that we say in any event, there's no violation of the right of the claimant companies to engage in their trade or business. In the Fort Street tourism case, it was said that it's about the opportunity of the citizen to engage in a trade or business. Now, the companies, even if they do qualify under 15.1, are not being denied the opportunity to engage in trade. They're simply having their profits reduced in the language of all UP Stamp Vendors Association. And we've quoted that in our statement at 28.4, I think, of the original October submissions, and I've already quoted it to the court, where they basically say you can't say that your right to work is being violated because your profitability or reasonable rate of return is being affected by a change in government, a shift in government policy. And then finally, we say Section 15 is a qualified right, and the relevant restrictions here are under the public safety, public health, and the protection of the rights of other persons, including the public interest of the Belizean citizens. And Justice of Appeal Balkan accepted that each of these reasons were in the public interest, but he respectfully, we say, got it wrong in suggesting that it was apparent that none of those goals identified were served. One of them clearly was, that's to say storage, and we say that there is justification on what he called the police power there. And I've made the point that the decision to increase storage capacity is justified in the interests of Belize generally, the interest of individual citizens in Belize, and that there are reasons of health, of safety, and of energy security which justify this intrusion, if it is an intrusion. And we say that it is reasonable and proportionate. And my lord, I've given you the quotes, sorry, if you want, I've given you the quotes about from the cases saying that there must be deference to the legislature in areas such as this in assessing proportionality, and we would say particularly in this area. So those are the final points we make. And then as to the freedom of association point, I just simply make we say that on that Justice of Appeal Balkan was entirely correct. We adopt his reasoning. We say that if one looks at the question of whether this could be a freedom of association, it's a very tenuous argument. He was right to rely on the definition of Chief Justice Wooding in Collymore about it being about the right to associate in some form of collectivity. He was right to require some form of collectivity. And if we look at it in balance, the argument that my learned friends advance on that was rejected by Chief Justice Wooding in Collymore, by Justice Kawali in the Bermuda same-sex marriage case. It's contrary to the jurisprudence of the European Court, cases such as McFeely, where they say it doesn't confer a right to socialise, and all that was relied on by my learned friends was the atypical and entirely unreasoned statement of Mr. Justice Williams in the Smith and the Attorney General case. So we say it's an atypical, eccentric and incorrect decision and should not be followed. It's against the whole history of Caribbean interpretation of the right of freedom of association. I think I'm within my 50 minutes.
Yes.
Just. And I know that we have important matters to hear from Mr. Marshall. So
Thank you.
Unless the court.
Well, no, I see no further
Thank you very much.
requests
Thank you.
for questions, please. Thank you, Counsel.
Well, Your Honors, as is usually the case, The issue of whether or not to remit is normally considered after all the heavy lifting on an appeal, when all are tired. Scant attention. Paragraph or two at most. No comprehensive guidelines have therefore yet been squarely laid down by this court governing nature, scope, or manner of exercise of broad discretionary power to remit. Albeit, there are a number of examples of circumstances in which the order to remit have been made, from which some basic principles can be distilled. It is clear from those examples and from decisions in other jurisdictions that the decision to remit should be carefully exercised in each case based on the special circumstances of the case, and that in doing so, some regard should properly be had whether or not the order for remission unfairly permits a second bite at the cherry by allowing pleadings and/or evidence to be revisited and enlarged upon at the further hearing.
Mr. Marshall, like the order to remit, that power would be in the discretion
Yes.
of the judge, and so I imagine you will get to let us
Yes.
know why you think that it was exercised wrong.
Certainly, and I can do that fairly quickly. There is a broad discretionary power to remit. We say that the Court of Appeal was wrong to remit in the circumstances and for the reasons they gave, because they failed to take into account matters that ought properly to have been accounted for in the exercise of discretion. That is the basic, and the reason we say that, there are a number of them, about 10 of them, but the linchpin of it, to get to it, given the hour, is that the respondents were given a fair and full opportunity to plead and prove the value of the loss of goodwill, which they asserted was taken at trial, and they chose not to do so. That choice tilts the balance of considerations, the exercise of discretion in favor of no remission, because they ought simply not be afforded a second chance to do what they chose not. This is one of the,
Sorry, where did we find that? I have seen the statement made, but remind me for present purposes, where we see where they were given the opportunity of, I think, calling expert evidence, I think, as put in the submissions, and they chose not to do so. Where in the record do I find it?
all right, at the very beginning, the issue of goodwill was raised first on the application for the value of goodwill was raised first on the application for the injunction at the very beginning of the claim, when they disputed whether or not Mr. Trejo was in any position to offer any value of goodwill. So from the very inception of the claim, the issue was a live one. So they had the opportunity from then to make any applications they could wish to make to adduce evidence as to value of goodwill. They did seek late in the proceedings to offer expert evidence, but they did so in relation to the feasibility of the 1.5. They chose not to do so in relation to goodwill. The argument in relation to goodwill, well, it's a sketchy concept. So whatever lost profits we've shown, treat that as goodwill, as the loss. Of course, that has no basis. In fact, there's no reason, there is no evidential basis, not even conceptually, there's no conceptual basis for treating the value of goodwill in that fashion. But for a specific reference, I have two instances in the transcript of the proceedings before the High Court, appearing on page 4431 of the record.
4431.
Yes.
Uh-huh.
It's useful to look at the whole exchange. I've distilled it down
Right.
to this. The court, he says, I think he's just pointing out that there's a gap in your evidence, because was cross-examining the witness, and there were certain objections taken. And I was pointing out that the evidence being offered by the witness was incomplete as to loss, value of loss, was incomplete. And certain objections were raised. You'll see the exchange. But the heart of it is that the response from Mr. Mendez was, if it's not there, it's not there. And again, if you go the page before,
Sorry, which one?
page
Next page.
4430,
Oh, the page before, 4430.
this is the prelude to that same exchange. So Mendez says, my lady, the evidence is the evidence. If it is that my learned friend is saying that the evidence is lacking in certain respects, then we can deal with that in submissions.
Okay.
So it's not that they weren't aware all along that there was no evidence, no complete evidence as to the value of the loss they were alleged. They were fully aware of it. They made a choice not to address it.
Mr. Marshall, you said that there is a discretion
Yes.
as to whether to remit or not. Where is that discretion?
The power to remit resides in section, and that's how I had started, but I moved to the middle given the time constraints.
I think that's
Section
30.
206D of the Senior Courts Act.
Oh, I see.
And that provides, on the hearing of an appeal from any order of the High Court or a judge thereof in any civil cause of matter, the court may, if it thinks fit, B, where the case was not tried by the High Court, remit the case to the court of trial for further hearing, with such instructions as regards the taking of further evidence or otherwise as appear to it necessary. And in all other cases, remit the case with such instructions. And I say this because this is what appears in the statute, instructions of the High Court. I think it should have read to the High Court.
Yes.
I make no issue of it.
I raised that because I was just wondering how you reconcile that regime of discretion.
Against
with-
section 20.
Yeah, section 20 of the Constitution.
Yes. Yes, Your Honor, I saw the treatment by Your Honor in your dissenting view in the Belmopan case. And we have relied upon it because the full and fair opportunity that was afforded the respondents to present this evidence and the requirements of fairness that they not be afforded an opportunity to begin because it was a choice they made is one of the, I think your language was the procedural and evidential protections that would have inured to the appellants by virtue of the course of action of the trial. They chose to conduct the trial in this fashion. There are certain consequences for having so chosen. One of the consequences is that they don't get a second chance at a compensatory award. And I say that based on the decision in Titan. In Titan, the court did not remit, did not exercise discretion to remit. The evidence as to loss of the value of the business was rejected by the trial, by the judge. The expert evidence of loss was rejected. It was rejected because at the end of the day, by the Court of Appeal, sorry, not trial judge, because at the end of the day, the court found that the operating and substantial cause of the loss was the suspension of the license and not the constitutional violations that had been alleged. In those circumstances, they did not decide to remit because there would have been very little point to it, given the finding as to causation. But where we are with that, what Titan really demonstrates, because the court was very clear that in constitutional claims, whether they're claims for compensatory awards pursuant to Section 20, there is an obligation to plead and prove the loss. And one step further, show that the loss was caused by the constitutional violation alleged. And to take it a step even further, where none of that has been established, that it's appropriate for relief to be fashioned pursuant to Section 20 on the basis of some other award. The right to the compensatory award is effectively forfeited by the failure to be put to the requisite standard. In Titan, the claimants, the appellants, were confined to a vindicatory award. And this brings us to what is our conclusion in this case, which is that if it is that this court affirms that there has been some constitutional violation, and if it is that the order for remission is to be set aside, then it's appropriate for some vindicatory award to be considered the award. The case for the respondents is that the vindicatory award should be made in addition to the compensatory award, which was made by the trial judge to be assessed. We say that if it is that a compensatory award is to be upheld, then there is no need for a further vindicatory award. The better position overall, given all the circumstances, and I'll take you very quickly through them by bullet points, is the former position, which is that the order for remission is set aside and some vindicatory award is considered instead, like in Titan. We say that there's no reason.
Hold on, just a minute. just a
Sorry.
minute. I mean, it's not just a swap-in thing, right?
Yes.
There's some jurisprudence as to when a court should order vindicatory damages.
And that needs to
So
be
that
observed.
I think the starting point should probably be whether, in the circumstances of this case, assuming a breach, the criteria to be considered and weighed that justify awarding vindicatory damages, what are they? Have they been satisfied? I don't think it's, if you can't award compensatory damages, give them vindicatory damages.
No,
I hope that's not what you intended.
no.
No, okay, yeah.
There is a consideration, there is some suggestion that vindicatory awards are available where compensatory awards are not in themselves sufficient to express the outrage, to deal with to be an appropriate deterrence to that kind of activity going forward, and a vindicatory award is added on top of it. But as in Titan's case, where there were clear constitutional violations, they found that the loss that would have been required to be pleaded and proven in order to support a compensatory award, not having been sufficiently, not having been proven because of the causation issue, that they were left only to the vindicatory award.
Yes, but I think my brother is pointing out that one doesn't necessarily follow from the other.
Yes.
So that to get to the vindicatory award, there are certain criteria that must be
Yes.
proven. Outrage, high-handedness, I think, was used in the Titan International case and
Yes.
so on. So
Yeah.
I don't know whether you're conceding that vindicatory awards are to be awarded in this case.
No, I'm saying that it's appropriate to consider
Yes.
granting such an award if the order for remission is not made. It becomes, I think it becomes easier to justify, although each and every one of the criteria
So
in the
if we
jurisprudence
were
still
to
needs
do
to be
that, what sum
satisfied.
would you suggest to us?
Sorry?
If we were to follow your advice, what sum would you recommend to us?
We say there is no reason to treat these respondents any differently from how the respondents before, I'm not sure which party they were, but like how Titan itself was treated.
But that was $100,000.
That was $100,000. That was
Your
$100,000.
We're
position-
getting closer all the time, aren't we?
Yes. But I'd like to take you through the other reasons why we say that there was a wrongful exercise of discretion, because they're equally important. But I highlighted and emphasized the choice that was made in how the proceedings were conducted as the consideration that clearly tilts balance. favor of no remission. The appellants say that the Court of Appeal erred in the exercise of its discretion to order remission for those reasons and in those circumstances, and those reasons that they give were one, that not only were special damages not particularized in the claim, but the figures presented in the evidence and tested under cross-examination were too generalized, unsubstantiated, and lacking in cogency to justify an award. There was only prima facie evidence of loss of profits, but the evidence was unreliable. There was no evidence of value of any goodwill because expert evidence was required to demonstrate that, and no such expert evidence was offered. And four, the respondents suffered extensive and debilitating financial consequences. So it would be unfair to them not to be compensated for direct consequences of constitutional violations. Those were the findings of the trial judge. They start at paragraph 57, 156, 157, 164. We say they were wrong to do it in those circumstances, firstly because damages were neither pleaded nor proven, so that not only would additional evidence be needed on a further hearing, but the pleadings would have to be amended to accommodate a new case on damages. See, you have a pleading issue here too, not just an evidentiary one. New pleadings and new evidence effectively means a new trial. And there is no good reason for offering the respondents a second chance at pleading and proving damages in a new second bifurcated trial on damages. In any event, the power to remit contemplates a further hearing of the original case and not a new trial with new pleadings, even if bifurcated. It was always open to the respondents to plead and prove their case on damages, and they chose not to do so. This, we say, is the linchpin. They instead pursued a generalized claim alleging a multiplicity of breaches of fundamental rights and making a multiplicity of complaints of financial losses, and neglected to make any attempt whatsoever to establish any connection between the two. The respondents adverted to the need for expert evidence in support of their claims of unconstitutionality of the amended NLP Act and sought leave late in the proceedings to produce it. They made allegations relating to the value of goodwill from the injunction was first applied for at the very beginning of the claim and could have sought to produce expert evidence as to value of goodwill lost at any time thereafter, but they chose not to do so. The Court of Appeal wrongly conflated the extensive and debilitating financial consequences to which it referred to found the order to remit with direct consequences of constitutional violations, having already found that damages were neither pleaded nor proven. There was simply no reliable evidence of any direct financial consequence of the legislation or of the constitutional violations, which could support any finding of any value of losses, so that those losses could hardly have been properly described as extensive or debilitating. The respondents were well aware of the evidence of loss presented in support of their claim for damages, that their evidence had gaps. They were well aware of it. Notice the exchange at the transcript, page 4431, which I've already pointed toward. We say that to offer the respondents a second chance to plead and prove damages is manifestly unfair to the appellants and violates the principle of finality of litigation and ignores the entitlement of the appellants to the procedural and evidential protection inuring to them by virtue of the course which the litigation took, as recognized by the President in the Belmopan case at paragraph 175. Consideration of these entitlements bears even more significance in this case because the respondents were warned that the evidence of loss presented at trial was lacking, and they chose not to address it, but instead deal with it in submissions. This was made clear by Mr. Mendez, and we refer the court to page 4430 as we did before. The court did not advert at all to or consider the fairness of its order to remit from the perspective of the appellants. Specifically, it did not weigh in the balance any at all that the respondents were already afforded a full and fair opportunity to plead and prove their loss. And I come back to this full and fair opportunity because if there wasn't a full and fair opportunity, some error was committed, that is a basis to allow them another chance to do it. But where you've had a full and fair opportunity and you've made a choice, there is no reason fairness would dictate that no second chance be afforded. It was certainly not the case, and my friends rely on the Belmopan case, the reasoning of the majority in the Belmopan case, but it was certainly not the case in Belmopan that the appellants chose not to tender expert evidence in support of their claim for compensation damages at trial. This choice of the respondents in this case effectively takes it outside Belmopan and tilts balance of consideration and discretion. In that case, there was a dissenting view expressed as to how the discretion should be exercised. It may have been more finely balanced. But in this case, where they chose not to produce that evidence, when they had a full and fair opportunity, it must weigh more heavily in the decision. Again, we say that in accordance with Titan, should be confined to consideration of a vindicatory award. We say that the effect of the failure to plead and prove the evidence necessary by evidence, the losses required to found a compensatory award, effectively precludes recovery of a compensatory award pursuant
Sherlock,
to
let me
Section
ask you
20.
something. You say that, of course, the Court of Appeal should not have remitted. So suppose we reach as far as damages. What do you say about the assessment by the High Court?
There was no assessment by the High Court.
Was there an order for damages?
Yes, there was.
Uh-huh.
It was lifted from the submissions of.
No, what I'm asking is, if it is that you are saying to us, the Court of Appeal chose the option to remit.
Yes.
You are saying we should not.
Yes.
If we reach this stage of having to consider compensation and we don't remit, what do we do? What do you say we should do?
You need to consider some other form of relief pursuant to Section 20. But there is no basis for any compensatory award.
All right. So that the High Court assessment, you say it's not an assessment, that is not a viable option. No.
In fact, the evidence as a whole, and I can explain why.
And just for the record, because you haven't covered that, I'm just trying to get you to just understand your position on that.
Yes, there's been no appeal against that aspect of the decision of the Court of Appeal, because when one looks at the evidence that was provided of loss, there is no way to rationalize it. The language that the Court of Appeal uses, saying that it lacks cogency and it's a general claim, all of those are very true and very real. And we can go through the details of each of them. But in short, all they did was to throw up a slew of make a slew of allegations of constitutional infractions and say we lost profits. And the lost profits must have been a result of this slew of infractions. Now the whole slew wasn't found, wasn't made out, and there was never any attempt to connect any particular loss to any particular infraction.
Mr. Marshall, just for certainty, you have indicated that there may be a basis for the court considering an award of vindicatory damages. Could you just confirm the government's position as to whether the criteria for such an award have been satisfied in this case?
We have taken the position in the appeal. They've appealed against the refusal of the Court of Appeal to make a vindicatory award, and we have resisted that on the basis that the reckless high-handedness, which is the very basis for making the award, was not made out factually. Neither the trial judge nor the Court of Appeal found that there was this reckless high-handedness that was necessary to found such an award. So in short, we were saying that in relation to a vindicatory award, that it was not appropriate, that the Court of Appeal was actually correct in not making one. But the considerations change a little. There is no compensatory award in that on the front end of that, on the front end of the consideration for a vindicatory award is whether or not a compensatory award is sufficient to do the job. And in the absence of that, then you get to the other criteria. But we say the other criteria aren't satisfied. Now that leaves you in the position of, well, how should a remedy be fashioned for in circumstances like this one? And really, the only instance when this has occurred has been Titan, and the way the court dealt with it was to make a vindicatory award. So maybe it needs to consider whether this is an appropriate circumstance for such an award to be given.
Mr. Marshall, I want to take you back to the right to work. The trial judge did not agree with that there was an infringement of that breach, that there was any breach, I'm sorry, of their right to work.
Correct.
Would it be that if Mr. Justice of Appeal Vulcan found that there was that breach, and when he looked at the fairness of the situation, that he should say, I think that needs to be remitted, that an assessment of compensation for that breach? Would have he been entitled to do that in your view?
Well, you're really in the same place in that no loss has been pleaded or proven as attributable to that breach, but there was a full opportunity to do so as well. So what do you do with that in the face of the decision in Titan that there is no blind and there is no automatic entitlement to an compensatory award under Section 20 where breach is established? The law is very clear. You must plead and prove it and show causation as well. But where you've done none of that, how do you still make such an award, whether on remission or otherwise? Some other way of vindicating the violation has to be conceived. In normal contract cases, the solution is to make a nominal award. Here, it can't be that there's still an entitlement to compensatory award without pleading and proving it at trial.
Yes, I think we have that one.
Yes.
We have that, Mr. Marshall.
Yes.
Yes.
And those are essentially our submissions on why there should not be remission. At the end of the day, we say the linchpin is there was a full and fair opportunity to present this evidence at trial. They chose not to do so. And I use the word chose very deliberately. It wasn't that they didn't advert to it. They chose not to do it. They chose not to do it. The material on the evidence on the proof of loss at trial was always right there in front of everybody. If you look at the transcript and the cross-examination, it was dealt with. Because all you had is these allegations and a bunch of numbers thrown up, and no way of rationalizing or tying them to any of the allegations. And at the end of the day, you can't say that Goodwill is a sketchy thing. So just treat the evidence as it was, as the value of that Goodwill. That just doesn't work. In fact, that's highly disrespectful to all the accountants that spend countless hours learning and practicing how to value and account for Goodwill. It is really highly disrespectful.
Okay, thank
Those are
you.
my submissions.
Thank you very much, sir. I see no further questions. Thank you.
Thank you.
I think we will break for the lunch at this stage and return in an hour from now, 5 minutes after 2. Thank you. Yes, Mr. Mendes.
Good afternoon, Your Honors. I am opening the batting this afternoon. I will probably be the 11th man as well. I'll be dealing with the question of the right to property and equality, and alongside equality, I'll be dealing with the application of the proportionality test by the Court of Appeal. I may or may not finish all of that by the end of today's proceedings, but thereafter, I will also address the question of the remission of the issue of damages to the court. And then my learned friend, Mr. Smith, will deal with the right to work and freedom of association, but that is most likely tomorrow. I want to start by just some dealing with some preliminary factual matters, and importantly, drawing your attention to what happened before the legislation, which brought the legislation into being. And that, of course, is what has been referred to in the proceedings and in the evidence as the definitive agreement. And that definitive agreement you will see in the electronic record beginning from page 3873. And what we learned from that definitive agreement is that there was a memorandum of understanding dated the 8th of May 2017, which was entered into between the government of Belize and a company called Belize Natural Energy Limited. And Belize Natural Energy Limited is described in the preamble to the definitive agreement as a company which has accumulated substantial experience and expertise in crude oil and liquefied production gas, delivery, distribution, etc. Now, that company is described by Mr. Waite in his cross-examination as the competitor of the complainants. You will see that at pages 4614 and 4615 of the electronic record. And in that cross-examination, you will see Mr. Waite giving us some insight as to how this entire project began. And he makes the point that this was as a consequence of the initiative of investors. And you'll see that at pages 4613 and 4619. So what he says in that cross-examination is that there were certain investors led by a Mr. Canton, who was the principal of Belize National Energy. They approached the government with the idea for this project, and that is what led to the Memorandum of Understanding and then eventually led to the definitive agreement. He also says in his cross-examination, and you will see this at pages 4618 onwards, he was shown the list of shareholders of what eventually became the National Gas Company. And you see that list of shareholders at page 2751. And interestingly, he did not know any of the shareholders. He didn't know about them. They were all companies really, except of course the government, including the major shareholder, which was a company which was described as having its residence in the United States. And of course, we don't know who is behind that company in the United States. There's no evidence before the court. And Mr. Waite himself did not know who was behind that company, and you would expect him to know, given his position. But he does describe one of the shareholders, G.A. Rowe, as being a large insurance company in Belize, and Bowman & Bowman being a large conglomerate involved, I think, in food production and but he describes it in the his cross-examination. So that is the backdrop to the definitive agreement. One of the, I should say, the main instigator appears to be Belize National Energy Limited, which was, or was at the time, a competitor in the market with the respondents. And obviously they saw an investment opportunity and they approached the government with this investment opportunity, and that led to definitive agreement. And of course, Your Honors, this is important to look at the terms of the definitive agreement, but from listening to my learned friends, I realize that the time is eaten up very quickly. So I'm not going to spend the time reading through it, but I'll just give you the highlights of it. But I, of course, trust that you will read these terms in due course. First of all, in the recitals to this agreement, which is dated the 10th of July, 2018, you will see it being said that by the time this agreement was entered into, and therefore, sometime I suppose between the memorandum of understanding at this point in time, the terminal had already been constructed so that there was expenditure already undertaken. And then there were a number of promises and obligations given and undertaking by the government of Belize, including some of the rights and benefits that were granted to the National Gas Company under the Act, which, for example, all of the tax breaks, the foreign exchange exemptions and so on, they are all in this agreement, and they find their way into the legislation eventually, as well as in this definitive agreement is included the way in which the wholesale price was to be calculated. And that formula, by and large, finds itself in the schedule to the Act. Importantly, you will see there are certain conditions precedent to the agreement, to the entering into force of the agreement, and that is contained in paragraph 5 of the definitive agreement. And it is, interestingly, that the legislation has been duly enacted in form and manner satisfactory to the developer within a practicable time frame. So a condition is that the developer, which is the NGC, is satisfied with the legislation that is enacted to give effect to this definitive agreement. And it makes clear that the condition precedent contained in clause 514, that is to say that the legislation is satisfactory to the developer, is a legislative requirement which may not be waived by the parties. You then see later on that this is in paragraph 6.4, that the government agrees that in accordance with the agreement and in furtherance thereof, shall pass enabling and other necessary and or prudent legislation, but not limited legislation hereinafter drafted, hereinafter defined, to ensure the realization of the terminal project facility and project, and to provide further support as may be required from time to time. So these are obligations that the government is undertaking. Then you will see in paragraph 15, the undertaking, the obligation that is placed on the government to enact legislation. And I'll invite you to, it's very, very detailed, dealing with the exemptions from taxes and so on. But importantly, there's the obligation to pass legislation which would give the developer the exclusive right to import LPG into Belize. So all of that is there, but even more importantly is clause 18, where the government gives an indemnity. And if I may just summarize the indemnity, it is basically that if it turns out that the legislation that is passed that implements the definitive agreement is in any way affected by any order, including judicial order, then the government is to indemnify the national gas company from any damage, I suppose, that has caused as a result. Now, so that is the backdrop to all of the events that have been described in the various affidavits that have been put before the court. But again, I trust that the court will eventually read all of these documents so that it
Before
saves me some time.
You move on, which I sense you're about to do. Are you suggesting that this is not the normal PPP arrangement, public-private partnership arrangement, or are you suggesting that the government of Belize did not give due consideration to issues that you have raised, and that following those due considerations did not enact the legislation to which you refer?
I don't know what a normal PPP arrangement is to be able to say this is out of the ordinary. But I know certainly that what is out of the ordinary because of pronouncements of this court is that it is not lawful, or at least not appropriate, for the government to give guarantees as to what legislation will be passed. That certainly is, again, I don't know if that is out of the ordinary for these types of agreement, but certainly it is. It has a taint of illegality in it. But again, I'm not, the purpose of pointing all of these things out to you is to later on address the question or address the submission that has been made by my learned friends that the Amendment Act was supposed to have leveled the playing field. So I'm just pointing out to you the advantages that the NGC has started with from the very beginning before I come to that. So I'm just laying the groundwork, as it were, to make these eventual submissions. Now, the original act was passed on the 4th of September 2019, and I think it took effect, operational effect, that is to say, NGC began to operate sometime in 2020. I don't recall the exact date at the moment. But as promised, that act in Section 5 made the developer the exclusive importer of wholesale LPG into Belize until the expiration of the term of the definitive agreement. In Section 6, there was a provision that required all LPG to be imported through the terminal, and the terminal that is referred to is the terminal that has been erected by or pursuant to this definitive agreement. You have Section 7 dealing with exemptions from taxes, exchange control, etc. You have Section 10, as my learned friend pointed out, dealing with how the wholesale price is to be calculated pursuant to the methodology that is contained in the schedule. And also, as my learned friend has pointed out, and very importantly, that an important element of the formula for determining the wholesale price is what is referred to as the financing fee, which you will see at paragraph 5 of the schedule. And my learned friend read parts of it to you. This is at paragraph 5 at page 808 of the electronic record. And it includes all financing costs and principal or capital payments, repayments, returns associated with equity and debt financing of the project, including but not limited to principal and interest payment on loans and fees associated therewith, coupon interest, sinking fund for principal repayment, annual dividends to shareholders, sinking fund for recovery of initial equity investment, and so on. And as my learned friend pointed out, in subsection 2 of 5, there's then how you go on to calculate that by dividing it by the a certain number of gallons, 11.5 million gallons. So built into the price that was to be calculated in accordance with this schedule, all of the financing expenses, if I may put it broadly speaking, that the NGC would have occurred, including the annual dividends paid to the shareholders. And of course, in the act, there is no indication as to how those annual dividends are to be calculated. That would presumably be determined by the directors. And of course, the directors then say that the shareholders are to get these particular annual dividends. And the act is designed in such a way that ultimately those who are going to buy LPG wholesale from NGC will pay for it. So there is, all of this is a grand scheme to finance not only the construction of and operation of the plant, but also the return on the investment of the investors who dreamed up this plan in the first instance and took it to the government, according to Mr. Waite. The Amendment Act, as you have already heard, removed the exclusive right to import that had been vested in NGC and replaced it with a Section 5, which you will find on page 576. And it is important to look at that section as well, because it says that subject to sections 5A, 6, and 6A, as of the commercial operations date, the developer shall have the right to import LPG into Belize and to engage in the business of selling and distributing LPG in accordance with Regulation 3 of the Supply and Controls Board regulations or any other applicable regulations in effect from time to time. There's a later provision that
What section is that?
This is section, it now becomes Section 5. It is.
Oh, so it's Section 4 in the
It is
Amendment
Section
Act.
4 that
Right,
introduces
right.
the new
Okay.
Section 5.
No, I
I'm sorry.
understand, sorry.
And the point that I'm making here, and again I will draw your attention to it later on, is that although it appears from an interpretation of the Act as amended that everyone has to get a license to import, no one else but the NGC has a right to import and a right to sell and distribute LPG, which goes beyond, it seems, the right to import. Everybody else has to apply for a license to import, and then everyone else has to, as is the normal course previously, have to apply for the license to retail, as the case may be. And it is also important to note that although the responsibility to determine the wholesale price is now vested in the controller of supplies, that is by way of the new Section 10, which is introduced by Section 9 of the Amendment Act. When you look at the schedule, the financing fee aspect of the wholesale price is calculated in the same way by reference to the financing of the project. And of course, to also taken into account is the annual dividends that are paid to the shareholders. So that is essentially, in a nutshell, if I may say, the scheme that has been set up by the Act. Now, so if I can get immediately to the right to property. Section 3, as my learned friends point out, speaks of the enjoyment or the entitlement to the right to protection from arbitrary deprivation of property. That is in Section 3D, which you see at electronic page number 7980. And then Section 17 of the Constitution deals specifically with protection from deprivation of property. That's a side note. But it says that no property of any description, shall be compulsory taken possession of, or no interest in or right over property of any description shall be compulsorily acquired, except by or under a law that does certain things. And the first thing is that it must prescribe the principles on which and the manner in which reasonable compensation is to be determined. And then it must provide any person claiming an interest in the right over property, right of access to the courts for the purpose of establishing his interest, determining whether the taking was duly carried out for public purpose, determining the amount of compensation, and so on. Now, of course, this legislation that is under challenge here does not contain, does not prescribe principles for the calculation of reasonable compensation, nor does it provide for access to court for these various things, obviously because the legislators did not think that they were taking property. But the point being that if in fact this court determines that the legislation does take property or compulsory acquire property, then it will be legislation that does not comply with Section 17(1), and it is a candidate for being declared to be inconsistent with the Constitution to the extent of that inconsistency. And I make this point, and I think it's important to emphasize that the right under Section 17 to have your property taken under a law that provides for a mechanism by which you can be compensated for the property that is taken exists even where the reason that the legislators have decided to take your property is in the utmost interest of the nation as a whole. So, just to make it clear, the government of Belize, albeit they didn't initiate it, it was initiated by investors, took the decision that it was in the interest of Belize to establish a 1.5 million gallon plant, storage plant, through which all imports of LPG was to be channeled in Belize and then sold to whoever wished to have it thereafter on a wholesale basis. And they took the decision that it was necessary to finance this plant, which was by all accounts, by all the evidence before the court, including the evidence of the expert. And there was no other expert to challenge that evidence, by the way. It was an expensive venture, and therefore you had to find a way to finance it. And the way that the government and these investors came up, what they came up with, of course, including a mechanism to reward the investors for the risks that they were taking, is to make all these concessions to the developer, tax breaks, and initially, of course, to have the exclusive right to import. And of course, the importance of the exclusive right to import is that you corner the entire market so that you're assured that all sales of LPG in Belize would come through this particular entity. So the government of Belize, in its wisdom, thought that this was the best thing for Belize. Now, just to make it clear, it is not for this court, except in extreme cases, to second guess the government of Belize as to what is the best thing for Belize. I would say that if any question arose, if the legislation had provided for access to court to determine whether this acquisition was duly carried out for public purpose, I cannot see any argument that could be made that it was not for a public purpose. But the point is that under Section 17, there's an obligation to provide for compensation for taking someone's property, even where the property is being taken for a proper and unchallengeable public purpose. So it really takes my learned friend's case nowhere to say that you can't second guess the government as to whether this is a good thing for Belize. Because if property was taken, then the legislation had to provide for the mechanism for compensation that I've just referred you to. Now, and that, I don't want to have to repeat that, but that is the most important point. And this is a point that has been made in a number of cases coming out of Belize dealing with compulsory acquisition.
So the Section 2 exception, 17.
Except for Section 2. Except for 17.2. If the law falls under 17.2, obviously, this is there is no need for compensation.
Right.
That's basically it.
Right. And just
But the only, the
No,
only.
I'm just clarifying, because
Yes, I'm sorry.
you made a general, a sweeping statement. I'm just saying, except for section anything two.
Except for
Agreed,
section
right,
2.
yeah.
And of course, the only thing that you have been troubled with is and very faintly, because it really has been pressed home today, that it is, it comes under 2A in satisfaction of a tax rate or due. But we have dealt with that in our written submissions, and we rely on written submissions as far as that is concerned. I won't waste, I wouldn't use up the limited time I have to address that point. Now, so the question is, has property been taken? Has the respondent's property been taken? That's the question. Now, I don't understand.
Hold on, just a
I'm
minute.
sorry, madam.
This question, just because you've glossed over something which I understand and for expediency you have, i.e. what's the structure of the test we apply to get there. This question that you have come to is a question which determines, first of all, whether or not there is a right
Yes.
that has been infringed.
Well, we have to ask whether property has been taken.
I understand that.
Yes.
The answer to whether or not property has been taken is an answer to the question under property,
Yes.
whether or not a right has been infringed.
That's correct.
For you, that's step one.
Yes.
Right, okay. Mhm.
And I'm just saying that if the answer to that question is yes, then the legislation does not comply with the
Because of
Constitution
the non-compliance with access and a process.
and the process for compensation.
Yes, and
Yes.
that is it. Mhm.
So the question is, has property been taken? And the first question is there any property? Did the claimants have any property that is relevant to these proceedings at all? Now, I don't understand my learned friends to dispute the proposition of law that goodwill is property. What I understand them to be saying is that there is no evidence of goodwill. And of course, if they are right on that there is no evidence of goodwill, then there can be no breach of section 17(1) because there's no property to be taken, there's no property even to be regulated, and likewise, there would be no breach of section 3(4), which deals with deprivation of property. There would be no property that one could be deprived of. So we must first establish the existence of.
Sorry, are they saying that there is no goodwill or that there is no goodwill in the importation business?
But with however it is described, they're saying there is no goodwill.
No. Fundamentally, vastly, that is not what they're saying. And it is a matter which has exercised me greatly.
Well, Your Honors, well, maybe I've misunderstood because I understood my learned friend, Ms. Welsh, to be saying that we didn't provide any evidence. There was something we said about a 45%, but we never explained what it was.
That was exactly in relation to the issue whether there was the importation business acquired.
Okay.
And the essence of the importation business as pitched in the submissions is that aspect where there was a sale to wholesalers in Belize is what, as it were, classified or typified the importation business as opposed to the onward selling to retailers. So, yeah.
Well, I am apologize to my learned friends if I have misunderstood their submission.
Okay.
But just from the caption of what my learned friend, Ms. Welsh, said that she was going to address, which is whether there was any goodwill, and having heard, I thought she was saying that there was no evidence of it. But if I may nevertheless give my answer in this way. First of all, I will refer to the findings of the concurrent findings of the court below of the existence of goodwill, and then I will address the other questions that have been raised as to whether you can have goodwill in importation. If I may deal with it in that way.
Mr. Mendes, do you really need?
I think I do.
No, watch me. To go into whether there was goodwill, I think everybody accepts there was goodwill.
I'm not sure. But if I will take 5 minutes.
Take it from me.
I will. Yes. I'll take 5 minutes.
Rely on my confidence and my shoulders.
Well, if I can then shorten it by saying.
Before you shorten it, I
Yes,
think it is in my understanding of my conversations with Ms. Welsh
Yes.
that there was also a nuance about the wholesale.
Yes,
Goodwill. She and I had a conversation about Goodwill.
correct.
But I thought, to me anyway, she accepted, at least reserved her position for further response, I should say, that importation could inform the issue of goodwill, i.e. customer satisfaction,
Yes.
quality of product, and so. So my impression was that for her, goodwill is something that is a little more less easily concretely pinned down. It is something that you look at the whole operation and it goes to reputation and so on. So
Sorry, I understood her to be saying that all we proved was loss of profit, not goodwill.
yes,
This is why I thought that she was making the submission that we hadn't proved goodwill.
that is what I understood her to be saying also.
Well, if I can address it very quickly, having regard to the comments from Your Honors, in particular, His Honor Mr. Barrow, by just giving you the references, first of all, to paragraph 13 of the judgment of Chief Justice Arana, where she, and this is at page 5017 of the record, where she says the NGC abruptly seized the clients and the customer base of all 5 of these claimant companies that they had established in Belize over the past 30 years without compensation, therefore violating the claimant's constitutional right. Paragraph.
What paragraph is that, sorry?
This is paragraph 13 at page 5017.
Yeah, I'm not there. Could you just repeat that, please?
Page 5017, para 13.
And what does it say?
It says, the passage begins, to my mind, with all due respect to the arguments of Mr. Marshallek, for the defendants, there can be no doubt that the direct effect of the original as well as the amended act is that the NGC abruptly seized the clients and customer base of the 5 of these claimants that they had established in Belize over the past 30 years without compensation, therefore violating their right. Later on in that paragraph, she also says, as Mr. Mendez for the claimant has argued correctly in my respective view, the expected inevitable result of these 2 acts, original and amended, is that the claimants have lost a substantial number of the customers to the NGC in the same way as if the law had forced them to buy. I direct you later on at paragraph 13 is a very long paragraph. It goes all the way over to page 5022, in which she says, I find that the claimants have established on the balance of probabilities that their customers and therefore their goodwill has been appropriated by the NGC without compensation. And then you will see Justice of Appeal Balkan at paragraph 4, and this would be page 10 of the core bundle. Towards the end, he also says, being forbidden by law from importing, the claimants lost a substantial proportion of their customer base, which necessarily is acquired by the NGC. At paragraph 41, page 25, he says that the evidence for this argument is that over the preceding 3 decades, these companies build up existing customer bases, acquiring in the process long experience in a specialized sphere as established in the evidence. In other words, there's no need to resort to hypotheticals in the future because each currently has a customer base with an accompanying reputation, all part of being an ongoing concern. If the evidence is accepted, which the trial judge did, then the claimants have already incurred losses, including their goodwill, as a result of the exclusive right granted by law to the NGC to import LPG. You will see at paragraph 40.
Let's just pause.
I'm
I
sorry.
think in fairness to Ms. Welch's point, she was at pains to say that loss of a customer base does not amount to loss of goodwill. So at some point, I hope you address that.
Yes.
Because both of the judges, when you read what they say, maybe conflate, maybe too strong, but it can be read as if that is conflated. Maybe it is not. But I would certainly like how you respond to Mrs. Welch's point that loss of customers is, or even loss of profit.
What I'm addressing is, because Ms. Welch says that all we're complaining about loss of profits, I'm addressing the question as to whether we had customers which we lost to the NGC. And I'm saying there are concurrent findings of fact by the trial judge and by the Court of Appeal, and these are findings of primary fact. And of course, your honors have pronounced upon the court's approach to concurrent findings of primary fact in the Apsara case. So I'm just drawing that to your attention. But I'm going further to say, insofar as my learned friend raised questions concerning our reliance on this 45% number. It is, in fact, evidence that was given by Mr. Waite himself about the percentage of my client's customer base that was lost to the NGC. Those are figures that he himself gave, which he said was based upon the records of the controller and or NGC. And you'll see that in the cross-examination from page 4629 to page 4635. And if I can just read briefly at page 4629, just below line 15, I'm referring to his evidence where he says, now you say that the claimants control 90% of the country's supply via importation. And I asked who provided the other 10%. He says he can only speculate. I had asked him at some point in time, where are you getting these figures from? And he says from the controller's records. And then I say, and you say that the claimants supplied over 55% of the distribution and retail sales directly. I asked who supplied the other 45%. And he says, effectively, it was independents who were providing the other 45% of resale sales. So I then went on to ask him at, this is 4630, around line 15, but they would also be wholesaling a percentage of what they were importing to other persons who would then retail the product. Is that what you're saying? So I'm saying that my clients would be wholesaling to persons who would then retail. And Mr. Waite agrees, and I say, so, and okay, I say, and so that it is those other persons to whom they wholesale the product that they imported who would have been distributing and retailing the other 45% that you're referring to. And he says that is correct. So his evidence from their own records is the claimants are bringing in 90% of the LPG into Belize. 55% of that 95%, they are retailing themselves. The other 45%, they are wholesaling to independents, as Mr. Waite is referring it to it. And then those wholesalers, the independents, are then retailing that 45%. So this is where the 45% came from. The 45% that we're talking about, that's the 45% of the 90% being imported, are the claimant's wholesale clients. He then goes on to say later on that he, at page 4633, that he got this information from the National Gas Company.
The part before, you've got the 4633. Before 4633, what page were you referring to?
I was referring to page
4630.
Yes, I started at 4630. It goes on to 4631. Yes,
Thanks, I appreciate it.
and then later on at page 4634 to 4635, I ask him, but this is at line 5, but the 45% of independents, presumably they are buying directly from NGC now. Answer yes. So I say, so that again, just by way of ballpark figures, what you are saying is that collectively the claimants have lost the business of these independents that made up 45% to the retail market. That is to say, previously. That stands to reason. He says, lost the wholesale business as wholesalers. He asks a question. I says, well, these independents you said that made up 45% of the retail market used to purchase from the claimants. Now they're purchasing from NGC. He says, that's correct. They are getting their supply from the NGC, and obviously they would do that because it's only one price. Yes? He says, that's correct. And then later on that page, so I'm saying it's correct to say, therefore, that the claimants have lost the business of those independents that were responsible for the 45% of the market of retail sales previously. Agreed. So, to the extent that my learned friend wished to know where that evidence came from, it came from Mr. Waite himself. So we can take it, therefore, that 45% of the imports that the claimants brought in, they sold on the wholesale market, as it were, to what Mr. Waite referred to as independents, that is other wholesalers, and then they sold on the retail market. And those wholesalers, that 45%, are now with the NGC. And of course, he's agreeing it's because it's one price. Now, by way of figures, Mr. Nicholson had produced a chart, which you'll see at page 3720 of the record, which provides details,
What page?
3720,
Thank you.
which provides details of the gallons of gas that were purchased by a long list of companies, including the respondents in this matter, for the year 2021. So he has a monthly record of what was purchased. The total amount purchased for the entire year, that is 2021, in that document is 13,982,608 gallons. That is the 14 million that I think my friend Mr. Courtney was referring to. When you look at what the respondents purchased from the NGC at the top, it comes up to about 7.5 million gallons. That means that the other persons bought 6.5, let us say, million gallons from the NGC. And when you calculate that, that is just about 45% of the total. I'm just saying that is, as you may say, circumstantial evidence to support Mr. Waite's evidence that he said he got from the records, that the 40%, 45% of the respondents' wholesale market that they had before the legislation, those customers went over to
Mr. Mendez, so is that, Mr. Mendez, so the aspects of the record that you just drew our attention to, is that the basis for the submission that the respondents have made, that they no longer supply LPG on a wholesale basis, even by purchasing from the NGC?
That's correct.
Okay.
And the point is too that it makes sense because, I mean, I imagine that theoretically there would be the rare case that someone would purchase wholesale from the respondents because they don't have trucks to go and pick it up from the respondent and deliver it. And they would be prepared to pay the extra price for the trucking. But if these are wholesalers, and as the evidence indicates, then it would make sense that they go and get it from NGC themselves, because if the respondents get it at a particular price from the NGC, and if they are to make any profit on selling it wholesale, then they are going to have a markup. The persons, the independents to whom they are selling, obviously will figure, well, I can go and get it myself, and I'll save whatever markup the respondents would sell it to me at. And therefore, I'm saying that that is a logical commercial explanation as to why the effect of the grant of the monopoly to the NGC to import and to sell wholesale would result in those persons who are purchasing wholesale from the respondents in the first place would automatically go over to NGC. So,
just remember the core thing you're trying to answer here, as I understand it, is the argument by the appellants.
Yes.
There no goodwill loss.
To that, no.
Up to now, you still haven't answered how loss of customers, of loss of profit, the argument equals to goodwill.
Well,
you made the point that you have lost customers. You made the point that you've lost profit, but we own property as goodwill.
The point is that the point is that I haven't said that we have lost profit. I've said that we lost customers.
Okay, fair
of
enough.
course, obviously, if you lose customers, then it will result in you losing profit. But we are not saying that there's a property right in making profits. We're saying that there's a property right in the customers, because it's the customers really, which is that the customer base is at the heart of the goodwill of any company. And I'm going to refer you now to the authorities that tell you exactly what goodwill is. Now, there is no dispute in the evidence either that, of course, these companies have been operating for different periods of time, but certainly for over the last 30 years, And therefore, it's not surprising that you will find that over that period of time that they had built up a customer base, persons, in other words, who would buy from each one of them. I mean, these are, by the way, these are competitors, so that they would have different parts of that 45% who were purchasing wholesale from each of them separately. But it is not surprising that over a period of time, they will have customers to whom they would go to on a regular basis and purchase their wholesale LPG from. Now, is that goodwill? Is that property? Now, I'll direct your attention to the Manitoba Fisheries case, which refers to the definition of goodwill given by Lord McDermott in the Ulster Transport case. And I'll ask you to look at page 11011. That's the page I'm going to read from. The Manitoba case begins at page 11005. And this is Chief Justice Ritchie saying, in my view, the appellants, suppliers, and customers who it had acquired and cultivated over the years constituted one of its most valuable assets as of April 30th, 1969. And on the following day, that asset was completely extinguished, and the suppliers and customers were left with no choice but to purchase Freshwater Fish Marketing Corporation, which was created as of that date by the federal authority for the express purpose of enjoying a monopoly of the market in which the appellant had formerly prospered. The kind of goodwill lost to the appellant by reason of the act is, in my view, best described by Lord McNaughton in Trigo and Hunt, page 24, where he said, it happens that the goodwill is the very sap and life of the business, without which the business would yield little or no fruit. It is the whole advantage, whatever it may be, of the reputation and connection of the firm, which may have been built up by years of honest work or gained by lavish expenditure of money. And then you have a fairly more elaborate definition of goodwill on the following page, which is a quotation from the judgment of Lord McDermott in the Ulster case, as I've pointed out. And you see Justice Ritchie on that page in the second to last paragraph saying, in my opinion, viewed in this light, goodwill, although intangible in character, is a part of the property of a business just as much as the premises, machinery, and equipment employed in the production of the product whose quality engenders that goodwill. Now, my Lord, Your Honors, I'm sure it would, at some point in time, in the course of our respective practices when we were in private practice, we would have come upon persons being interested in buying businesses, and the first thing that they would ask for is your customer list. Who do you sell to? Because when you buy the business as an ongoing concern, you want to ensure that there are going to be persons who are going to purchase from you. That's an important, quite apart from the building that you're buying and whatever equipment that you might have. If you're going to produce something with that equipment or in the buildings that you purchase, you want to ensure that there's somebody that you're going to sell it to. And therefore, that customer base, which is built up because of your reputation, because of your efficiency, because of the product that you have provided, and because of the standards that you have maintained over a period of time, that is the goodwill that is being referred to. And the evidence is that that is what the respondents were able to develop over time. And the evidence is that those customers that they were able to develop and count on over time to generate their profits, that asset that they used to generate their profit, that asset, the goodwill, the customer base, is now in the hands of NGC.
Not all of it.
Sorry? The 45%. The entire 45%.
Yeah. Yes, I gather Ms. Welch was saying that goodwill is indivisible. So that the fact that your clients still maintain.
You will have noticed that you didn't cite any authority for that proposition. And indeed, that is contradicted by the Ulster case itself, which the legislation had created a monopoly or had prohibited the complainants in that case from doing one aspect of the business that they were engaged in. I forget exactly how it is. It had to
furniture removal, was it?
Yes,
Yes.
furniture movers, but there was some aspect of it that wasn't prohibited, so that they
Right.
could continue with it. And that question arose in the Ulster case, and it did prevent the court from saying that that they had lost goodwill.
But all of that aspect of the case had been taken away by the legislation.
Precisely,
Yes.
in that case, that aspect of the goodwill had been taken away. Yes,
Mr.
and in this instance, this legislation takes away the entire wholesale aspect of the
Above
of the
2,400 gallons.
sorry.
Above 2,400 gallons.
So I'm not.
No,
sure.
I thought that the NGC sold in units.
Oh yes.
Of at least
However, wholesale is
2,000, yes.
however it is defined.
So that
yes.
wholesale is still possible to your clients if they're wholesaling below 2,400.
Well, they would. I would assume. I would assume so, but
Yeah.
I'm not too sure of the exact amounts. I simply don't know how to answer that question here. I don't have the instructions to give you an answer.
Mr.
And
Mendes,
Thank you, Ms. I'm still trying to come to grips. Are you arguing that the customer base amongst the goodwill, or that is a factor that you would take into account when you are assessing, calculating what that goodwill is?
I'm saying that is the manifestation of the goodwill. That is the way in which the asset itself manifests itself. That is the money-making aspect of the asset. The cases that we're dealing with, which is Manitoba, what was taken in Manitoba and in the Ulster case, there wasn't a purchasing of the businesses. What happened in both cases was that the customers that the companies had and that they had built up over that period of time went over to the company that had the monopoly. So that the taking, in that case, the taking of the goodwill manifested itself by the taking of the customers.
I'll concede that Ulster might be a little different, but Manitoba is very, very different from this case, isn't it?
Well, it is different because you were dealing with exports, so that the
And
customer.
it's different from in the sense that the entirety of the business.
Well, yes, yes,
Nothing was left.
of course, but then.
Whereas in your case,
Yeah.
you still have your clients still have customers that they are retailing to, certainly.
Correct. So
And
that
possibly wholesaling, depending on the amount
So-
of the wholesale.
so that some of my clients were not forced to shut down entirely, but one was, and there were findings by the trial judge that was as a consequence of the monopoly that was created by the act.
Yes. There are different allegations about why that particular company closed down.
Well, there
of course.
are findings by the
The
trial
findings.
judge, but I don't think that those findings were appealed. Neither will they appeal. There's no ground of appeal before your honors, I don't think, in relation to that particular finding.
But Mr. Mendes, we're still at the stage one
Yeah.
analysis as I understand it. And the stage one analysis, so we have not reached proportionality yet. The question is there property?
Yes.
Goodwill is property.
Yes.
Was goodwill taken?
Yes.
Your argument, as you said, is yes.
Yes.
Now, does section 17 anyway say it to cross that threshold, it has to be the taking of all of goodwill? Is there anything in the language in section 17 which suggests
It says of any description.
any interest in or right over?
Yes.
So that the idea that, well, in Manitoba, these are cases which are illustrative of what happened in those factual scenarios. But for the purposes of stage one, if we are satisfied that goodwill is property, there is evidence of the taking of goodwill in this case.
Yes.
Is it that then we have crossed stage one?
Yes.
Right.
And that's it. You have established that there has been a compulsory acquisition of property. Once that is established, it is obvious that the act doesn't comply with
If
section
I have a
10.
piece of land, for example,
Yeah.
5 acres of land, and the government compulsory acquires one lot, doesn't take all of it. Is that not a compulsory acquisition because it
it's
only took
taken.
one lot?
It's taken, even though my interest might be in the whole, my title is in the
So
whole.
my
If the
question is,
government takes
why
part
should
of
it be
it,
different with Goodwill?
well,
If they take 1 inch of my land compulsorily,
precisely.
You can lose some of your customers other than through the loss of goodwill, can't you? Some of your customers may leave you, but that's not necessarily suggesting that goodwill has been lost, is it?
Customers from time to time leave for a number of
yes,
different
exactly.
reasons. But when you look at a company over a period of time, when you're looking at the value of the company itself, if you're selling it as a going concern, for example, you're selling it and you're taking into account all of its assets, physical assets, but you also take into account its goodwill. And that goodwill is represented by its customer base. The customer base fluctuates over time. You have more, you have less.
Yes.
Some people are unhappy with your product. Some people are happy, then they give you recommendations and it grows. But it's that customer base that you have which constitutes the goodwill. And in this instance, the goodwill that part of the goodwill, if you wish, that is represented by the wholesale, the wholesale customers were taken by the NGC. Now the point is that the NGC couldn't take the retail customers because they were not given by the original act the exclusive authority in relation to retailing. They were given only the exclusive authority in relation to wholesaling. They were the only source of it, and they sold it wholesale.
Okay. I think we should let you get on with the other segment.
Thank you very much.
Thank you.
Now, the point is that my learned friends then take the point that, well, if I may address the point that has been made, well, you can't have any goodwill in importation because importation is just bringing it in. You don't have, it doesn't involve selling it to anyone. In other words, it's being suggested that you are the only client. But that is, as both judges have held, the Court of Appeal and the first instance judge, is not a realistic way of looking at the issue because no one imports to keep. What's the point of importing all of these gallons and gallons of LPG just to put it there and look at it? The purpose of bringing the LPG in is to sell it, and you either sell it wholesale or you sell it retail. That's the whole point of it in the first instance. So effectively, even though the monopoly that has been given is the monopoly in importing, exactly what the NGC is doing, the entire business plan to be able to pay back for this investment that is made in a 1.5 million gallon plant is to import and to sell.
But Mr. Mendez, doesn't that suggest that the core business is distribution?
Wholesale.
No, not wholesale or retail, meaning the core business is distribution. It's supplying the product to customers in Belize.
Well, again, without even providing for it, if all they were given, that's all they were given initially, is the power to import, then that must carry with it the power to sell what you import. And if they needed, I don't know if they obtained, but if they needed a license to wholesale, then I think that having given you the statutory power to import, it would have been entirely irrational for the controller of supplies not to give you a license to wholesale.
Because I was struck when I looked at submissions made in one of the courts below, that there was this distinction made between import business, the LPG import business, and the LPG distribution business. But the description of the LPG import business read as distribution because it was import, sell, and I think distribution was described as transport and storage. But everything being described seems to be part of the elements that comprise distribution services.
Well, Your Honor, I imagine the language would have been used in accordance with what the Act was doing, which was creating a monopoly over importation. And it was only until the fairly remarkable argument that was made, which is that you have no goodwill in importation, and there's something different between importation and wholesale, that obviously one has to adjust one's language to reflect the reality. And the reality, as a matter of fact, I think that there is evidence, I believe we referred you to it in our submissions, that one of the witnesses said, I think it was in re-examination, that as a matter of fact, I import it and I bring it straight to my wholesale clients. I don't even store it, which indicates exactly what, that is no different from importing it, bringing it in, putting it into your storage tanks, and then selling it wholesale over time.
Yes, sir.
There's no difference between I am importing it and there's a particular client that that this particular truck is going to go to deliver. So I bring the truck in and I deliver it straight to my wholesale client. What is in practical and commercial reality the difference between that and in the language of importation? If you're being given the right to import, then it must come with it the right to distribute what you import.
Mr. Mendes, if I may, and please allow me just a little time to get my thoughts across to you. I am looking at page 5012 of the record, which is the beginning of paragraph 11 of the High Court judgment. And the High Court judge identifies issue number 3, whether the amended act is inconsistent with section 17 of the Constitution of Belize, as it compulsorily takes, let me just close this, as it compulsorily takes possession of and or acquires the goodwill of the claimant's LPG import business without any compensation.
Yeah.
So as I understand it, and as the judgment goes on, it deals with the goodwill in the claimant's LPG import business.
Yes, and I'm saying, what I'm saying, Your Honor, is that you would have to forgive all of us, including the judge, for using the language in a I suppose, to reflect what the act was doing. But you can't separate an import aspect of the business from the distribution.
Well, with respect, Mr. Mendes, you see, the reason why I come to this is because you can, it seems to me. Let me give you this example which has engaged me and on which I have been dying to get the benefit of your thinking. What the gas companies were doing, they were sourcing gas, and they sourced the gas by importing it. They did not have any business in importing the gas because here is where the business was. The business was in the supply to the gas companies of the gas. The persons over the border were the suppliers. If they were in a CARICOM country and Belize were to pass that legislation, which prohibited them from selling onto Belize, then they would have brought a claim under the revised Treaty of Chaguaramas for them, the suppliers, being deprived of their ability to earn their profit, destroying their goodwill because they could no longer sell to their customers, the gas companies of Belize. But they cannot bring a claim. So the only person who can bring a claim is the person who is doing the buying from them. The gas companies are buying from the people from across the border who sell them gas. The gas companies have no profit in selling, in that importation. Where their profit lies is having secured that LPG, is selling it on the Belize market.
I think that is in fact practical commercial reality. What happens, in other words, if we try to look at it from the point of view of how the company makes money, it makes money by selling a product.
Right.
and it makes money by selling a product to its customers.
Right.
And the customer base that it builds up over time by selling gas to those customers is
Wholesale and retail in Belize.
is what you would refer to as goodwill. Now, of course, in order to sell, you have to source it.
Right.
Now, if let's assume for the moment that in Belize you had a local source of
Right.
LPG because it was being produced, manufactured, whatever is the correct term, in Belize
Right.
itself.
Right.
Now, let's assume that my clients had the option to source from locally
Right.
as well as from abroad.
Right.
Now, if the source from abroad is shut down because the exclusive right to import is being given to someone else,
Or tariffs are imposed by somebody.
or whatever, then what they would do is to say, well, I'm not going to lose my customers because I will source the product from the local manufacturer.
It's not, hold on. It's not that I'm not going to lose my customers. It is that I'm not going to lose my source of supply.
Precisely.
I will not be able, I will still be able to obtain my supply.
No, but the point is that the company that gains the monopoly over that source of supply
Right.
that is from
Right.
foreign,
Uh,
that company, you wouldn't be able to complain that they have taken your customers,
correct.
because they only have a monopoly over importation. They don't have a monopoly over supply.
So so the local company, what has it done? It has taken away the customers of the suppliers from over the border. It is the suppliers from over the border who have a complaint,
But my customers that
are
is,
simply purchasers.
are continuing to purchase because I'm
Yes.
continuing to supply them.
Yeah.
And the point that I'm making is when the only source of supply in Belize is from importation, and you pass a law that says that I can't import anymore, that only a particular company can import, then the company that you are giving the right to import, along with, of course, the mechanism for determining the wholesale price and selling wholesale, if that becomes the ultimate wholesaler, then I will have lost my wholesale business. And I've lost my wholesale business, which is meaning my wholesale customers, because the legislation in the first place has denied me the opportunity to get a supply from abroad.
I will go back and read this exchange more fully, but I can tell you for right now, I don't see with it at all. Who has lost custom in the importation business is the supplier from over the border. They are the ones who are making money from selling to the gas companies.
Your Honor, with all due respect, the evidence indicates that the respondents have lost their clients. They had clients who they sold gas to, the wholesale clients,
I don't doubt.
but that's the evidence.
Yeah, I don't doubt. But that was not part of their import business. There was no import business.
Your Honor, they can't import without selling it to somebody, so that has to be part of their import business.
That was a follow-on from the process of importing.
Because they are only
You are the one who said if they were getting it locally, then they would not need to import. So it is not the importation
And
that was the
I
business.
use that example to say that if somebody is given the monopoly over importation, then I will not have lost my clients because I will still be able to source the product from somewhere else locally. But when you dry up the source and you give one entity the monopoly over the supply in the entire
Right.
country, then that person who has the monopoly will have a monopoly over the customers who purchase wholesale.
Mr.
And
Mendes,
that
just to
includes
follow-
my customers.
Yeah, but just to follow on from that point, one of the things I'm trying to figure out, and it's based on an argument I saw, a submission made by the Government of Belize. If a company has goodwill, right, which is intangible, it's a reputation that has been developed over time,
Yes.
the custom that allows customers to return to whatever they're offering. If the product can be sourced at the same price from two sources, the NGC or from the gas companies. Wouldn't one expect that all of that reputation that has been built up over decades might have influenced at least some of those customers wanting to purchase the product? It's the same price from the gas companies. There's a relationship that they might have developed with them over decades. What I'm just trying to make sense of is the argument is that there was goodwill that was built up over decades.
Yes.
The product is being sold at the same exact price because it's now regulated by two potential suppliers. One is the NGC, one is the gas companies. As I understand it, if the gas companies,
Sorry, Your Honor, that's not the that's not the
factual
premise.
matrix?
No, the factual matrix is that if the companies, we are not selling at the same price. We are purchasing at the same price like everyone else. Having purchased it, we then have to sell it. And in order for us to make a profit, we have to sell it, obviously, for it to make any commercial sense. We have to sell it at a markup. So what we sell it as, unless we are a charity, we are selling it at an amount greater than what we purchased it for from the NGC.
And the NGC is selling the product at that price to you,
Yes.
as well as to everybody else.
As well as to everybody else. And as a consequence of them selling it at that price to everybody else, that my customers have obviously decided, because otherwise they would,
Your
it would
argument
be
is the
commercial
evidence
madness.
shows- The evidence shows you
Yeah.
today that the 45% deficit on your side has been taken up
That's the
on
evidence.
NGC's side.
That's the
And so
evidence.
that NGC sells at the same price. Why would a person pay more for a product that they could get at a lower price? And because NGC has all the control of the source and the wholesale price, my wholesale customers not want to come to me because they'll have to pay more. They go to NGC. Isn't that what you're saying?
Yes.
All right.
And it's not only that, Your Honor.
I
this
think
is-
we have, for my part anyway, I think there are some other things that you may want to be telling us about.
Yes,
Quite
Mr.
a
Mayor.
bit of thing, but if I can just emphasize, please, that this is the evidence of the appellants. The appellants' evidence. Their evidence is
The Financial Secretary of Belize.
precisely
Right.
The 45%.
the 45%. It's their evidence that our customers are now the NGC's customers as a direct result of the legislation. With respect, Your Honors, that is the evidence that is before you. And the authorities indicate that the customer base of a company built up over time is their goodwill. The authorities indicate that goodwill is property. The question is they're taking. If the goodwill, that is to say, represented by the customers, was not taken from the respondents, then it must still be with the respondents. If it's not taken, then where is it? Customer base represents the goodwill, and if it's not taken, then it must still be with the respondents. But the evidence is that they are not with the respondents. They are with NGC. So it can't be anything else but a taking. Well, the friends have spent a lot of time.
A loss of profit is a loss of goodwill.
A loss of customers is a loss of goodwill. The loss of the customers will result in a loss of profits. We do not claim property in profits. My learned friends have tried to attribute that to us. We have never made that submission. The only way, respectfully, that they can get around our submission is to say that our case is that we have lost profit. We have never said that profits equates to property. We have said goodwill, and we have relied on the evidence of the financial secretary.
So your position is, if we agree with you on that, then 17(1) applies to the legislation. But this is
Yes.
a challenge to law.
Yes.
Right? The facts are the facts that help us look at the law.
Yes.
I.e., no provision in the legislation for compensation or access for the purpose of compensation.
Yes.
You don't need to go further than that.
Don't need to go
So
any further.
you don't need to reach, on that first argument, you don't need to reach a proportionality test.
Not at all. And of course, the second part of it is that the amendment did not give us back our property. And it didn't give us back our property. It couldn't, in any event, give us back our
No,
property.
wait. Does the amendment remedy the 17.1 constitutional procedures?
Yes.
Does it access and means method?
No, it doesn't.
Okay.
It doesn't provide for that. So it hasn't changed the situation. It hasn't changed the situation that our property has been taken away and the NGC has been enjoying it and making profits off of that property customer base.
You know, another way, and you may be coming to this eventually, that the appellants approach this is to say that law is regulatory.
Yes. I'm coming to that, yes.
And therefore, whilst there might be a deprivation of property, there is not a taking.
Yes.
Are you going to address us on that?
Yes, yeah. Well, first of all, I'd like to say that I commend the authorities that my learned friends have referred you to, that is the Great Bay case and the Campbell-Rodriguez case, which compare and contrast the types of situation that would constitute a regulation and the types of situation that would constitute a taking. As a matter of fact, in the judgment of, I think it is it Lord Hoffman in the Great Bay case? Yes, Lord Hoffman. You will see at page 72 of the report, but at page 10-244, he gives the contrast between the types of situation. It is well settled that restrictions on the use of property imposed in the public interest by general regulatory laws do not constitute a deprivation of that property for which compensation should be paid. The give and take of civil society frequently requires that the exercise of private rights should be restricted in the general public interest. The principles which underlie the right of the individual not to be deprived of his property without compensation are, first, that some public interest is necessary to justify the taking of private property for the benefit of the state, and secondly, that when the public interest does so require, the loss should not fall upon the individual whose property has been taken, but should be borne by the public as a whole. But these principles do not require the payment of compensation to anyone whose private rights are restricted by legislation of general application, which is enacted for the public benefit. And then he goes on to give examples of what would constitute restriction of private rights. And then he cites Manitoba as being an example of where there's a taking. And then he cites the Society United Docks case, and it's important to see how he describes that. And I'm running out of time. I wanted to go through that case with you, but I'm relying on the way Lord Hoffman characterizes the case. He says, and this is at page 10-245, the substantial effect was to enable the corporation to acquire their previous customers, that's Manitoba. Society United Docks, in which the plaintiffs alleged that their businesses had been destroyed by a monopoly of handling sugar for export conferred upon a statutory corporation, was treated as being in principle a similar case, but the plaintiffs failed on the facts because they were unable to show a causal connection between the establishment of the monopoly and the loss of their business. That is Lord Hoffman's, that's what Lord Hoffman takes from the case, and I'll ask when you read it, you'll see that what happened in that case was that it was agreed between the syndicate that was hiring the stevedore company and the storage company that the methods of storage and the manual labor that was being used by the stevedores was outdated, and that it was necessary to establish a bulk terminal. That was the technological advancement. In other words, before there was eventually the monopoly created, it had already been established that the methods being used by the companies was redundant. And therefore, what you see, I think it was Lord Templeman in that case, or Lord Diplock probably. And what he is saying is, and the learned friends rely on this, that you can't lose property if you lose it as a consequence of technological developments. Because in that case, that is what happened. Their method of doing things became out of date.
And the appellants are saying that your client's methods of doing things have equally become outdated. They are saying, if I may,
Sorry.
they are saying that the transportation of the LPG by trucks from Central America into Belize is no longer to be tolerated because there is a more modern, more efficient way of transporting the LPG via sea and depositing that in the marine terminal. So how do you respond to
Well,
that?
first of all, Your Honors, there is no evidence before the court that their method of bringing LPG into the country, which was happening for years and years, was technologically out of date. There's no evidence to that effect. What was pointed to was that there were health and safety risks and smuggling risks caused by bringing it over land. And the evidence established on cross-examination, I invite you to look at the cross-examination of both Mr. Waite and Mr. Nichols, in which they couldn't point to any incident. And Mr. Nicholson, as a matter of fact, he said that he spent months at the border crossings when these trucks were coming in, and he spoke about them lining up and so on. And he could point to no incident where there was a health or safety risk, no incident where there was smuggling, none whatsoever. Now, theoretically, one imagined that these things could happen, but it never happened. I'm saying that that is different factually, and as a matter of fact, if that was the case that they were making, that there was something technologically wrong about the method that was being used, then the evidence would have been different.
Mhm.
But the evidence was that there was danger, and that claim was never established by the evidence. In the Society United Dock case, on the other hand, the evidence was clear that it was agreed even among the stevedores and the storage companies that their method was out of date, and they agreed that they would move to a bulk storage scenario. If I may say, but just by way of observation, that things might have been entirely different if the government had approached all interested parties in Belize to invest in a 12 million gallon plant. If everybody bore the risk, including those who stood to lose because their customers would be taken over. That is what happened in the Society United Dock case.
See, Mr. Mendes,
All of them were consulted on the way forward.
It's an interesting point that concerned me, that one of the what is it, the agreement document.
Yes.
I forget what it's called, but
Definitive.
Belize National.
agreement.
Natural, yes.
Yeah, sorry, yeah. That a competitor enters into this arrangement with the state and effectively gets preferential treatment in relation to other competitors. Now,
Yes.
was that competitor also bringing stuff by trucks? Because the impression I have is that's the only way LPG ever came into Belize.
Well,
Oh, that's-
90%.
Sorry?
90%.
90%.
By the respondents. I asked Mr. Waite, who was the other 10% he did not know.
Uh-huh.
But when I asked him, was the Belize National Energy, I think it was he there, because the preamble, the recital, described them as being engaged in LPG distribution.
Yeah.
So when I asked him whether that company was a competitor of the respondents, he answered yes. So that's the background
No, no, I'm just
information.
asking, is it that they were bringing it in by truck, or were they bringing it in by sea in a storage facility?
We have no evidence.
No evidence of that.
They produced it in the use apparently.
You know, sorry. Are you finished on that? I wanted to take you back to something you had spoken about earlier. For a long time, you spoke about laws involving taking, expropriatory laws, if you will. And then for a few minutes, we started talking about regulatory laws. Okay. So, and I may have asked this before, but how do you distinguish between those two classifications, those two different kinds of laws? Can you help us on that?
Your Honor, I would say that one easy way to distinguish between the one and the other, certainly for the purposes of this case, and I'm not saying it is the only way to distinguish it, is where you find a situation where the property that is being regulated is still in the hands of the owner. So, we use a number of examples that have been given in the
Can you
authorities.
use that though? Because the Constitution speaks about property rights being deprived. So
No, no, I'm
if
saying that-
somebody's deprived of the property rights, it's no longer in their hands, is it?
No, what you're asking me how to distinguish
Yes.
general between the two.
Yes.
I'm saying that one way to know that it is not regulation is if you're not dealing with a scenario where the property remains in the hand of the owner, but it is restricted and the use of it is restricted in some way. Where you have a situation where the property is no longer in the hands of the owner, the previous owner, but it is in somebody else's hands, that is not regulation.
So the
That
first
is appropriation.
first category is the typical planning law, zoning law, for example.
That is a typical regulation. You still have the property and they tell you what you can and cannot do with it.
Right.
And that was the type of scenario that was being considered in the Campbell Rodriguez case. I still have my property, but you have affected it because you're now requiring people to pay tolls on the highway, and that is affecting their ability to visit me. That is impacting upon the property I still own. The authorities indicate, though, that even though you still have the property, you could regulate it in such a way, in other words, you go too far, that it constitutes a deprivation. In other words, I imagine it would be situations in which
You see,
the property
back to this, it still troubles me, because you put a competitor into the equation and then purport to regulate, as it were, others.
yes.
So is that a general regulation, and I suppose that's something I asked Mr. Cheryl about, and he said, yes, it could have elements. It's something I have to work out, but it's certainly, I'm happy the president raised it. It's something that I think we could benefit from, with a little more explanation. How do we discover what makes a law truly regulatory, or why is this law not? Maybe the way to answer the question for us is, why would you say this law cannot be classified as regulatory?
Because I don't have the property anymore.
All right.
I don't have it, so nobody is regulating it. I've lost it.
Certain nitpicking, but you don't have all of the property in it.
The property, meaning the goodwill in the
Importation business.
the wholesale aspect of my business.
Yeah.
I don't have it anymore.
So Mr. Menes, you accept Justice of Appeal Balkan's test going too far? You have no problem with that test at all?
Well, I don't think, yes, I do. Of course, one would have over time to flesh out exactly how you determine when you have gone too far. You'd have to refine it as on a case-by-case basis. I'm respectfully submitting that you don't have to apply that test in this case at all, because you would usually have to apply the test to determine whether regulation has gone too far to constitute a deprivation in scenarios where you still have the property, but it has been regulated in such a way as to restrict your use too far. I'm respectfully submitting that this is not a regulation case, because the property is not the property in my hands is not regulated because I don't have it in my hands. It's gone somewhere else. So this is not a regulation case, it's a pure out and out taking case.
You did say that you were batting at number 11.
Sorry?
You said you were batting at number 11. And I'm just reminding you that the close of play is about to come upon us. So,
Your Honor, I know I have an extra 20 minutes. Do I get that extension of time? We still have some light. Still have light.
I think some people are saying it's bad lighting.
I'm saying,
Mr. Menes, if it is a convenient time.
I think
we
bad
can
light.
come
I
out.
think bad light stop playing for today.
but I'm still claiming the credit of the extra 20 minutes from
in the morning.
learned friends took away from me.
In the morning.
In the
yes.
morning, it's all.
And just as a reminder, thank you, Council. I suspect my colleagues have no further questions at this time. But tomorrow, just to remind everybody, we start a little later. We start at 10 o'clock. And we will resume with you
Thank you very much.
The
Your
number
Honor.
one position, I suspect. Thank you, colleagues. To adjourn, Madam Deputy Registrar.
Thank you, Madam Justice Shortly. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jawada, and thank you, Madam Justice Romano, Lieutenant Counsel. Thank you to the students and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned for teacher forum.
Well pushed.